ಏನ್ ಹೇಳಿ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಯಾವ್ದು ಇಲ್ಲ ಇಶ್ಯೂ ಆದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ವಾರೆಂಟ್ ಇಶ್ಯೂ ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋಕ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ನೋ ನೋ ವೆಕೇಶನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೋ ಸಚ್ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್. ವೆಕೇಶನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ.
Will be arrested there, sir. Will be arrested since warrant is before.
ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ಹಾಗಾದ್ರೆ? Why you are waiting till last day?
Lord, yesterday I moved it not for today, but not listed, Lord. Yesterday I moved it.
ಯಾವ್ದು ನಾನು ಎಲ್ಲ ಮೆಮೊ ಹಾಕ್ಸಿ ಅಂತ ಹೇಳಿದೀನಿ ನಾನು.
ಇಲ್ಲ
ಯಾವ್ದು ಮೆಮೊ ಕೊಡಿ ನೀವು?
ಕೊಟ್ಟಿದ್ದೀನಿ, ನೆನ್ನೆ ಕೊಟ್ಟಿದೀವಿ.
ನೋಡ್ರಿ ನೆನ್ನೆ ಯಾವ್ದಾವ್ದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇಟ್ಕೋಬೇಡಿ ಎಲ್ಲಾನು ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ ನಾನು. ಹೌದಾ? ನೋಡಿ ಈಗ ಏನಾಯ್ತು, ಹಾಕಿದಾರ ಇಲ್ಲ ನೋಡಿ. ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ತರಿಸಿ. ನೆನ್ನೆ ಮೆಮೊ ಹೋಗಿದೆಯಾ ನೋಡಿ ಅದ್ರಲ್ಲಿ?
177
ಏನ್ 177?
ಇದು ಬೇರೆಯವ್ರ ಮುಂದೆ ಆಗಿರೋದು ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ, ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ ಕಲೀಗ್.
ನಮ್ ಮುಂದೆ ನೀವು ಮೆಮೊ ಮೂವ್ ಮಾಡಿರೋ ಅಲ್ಲಿ ಇರುತ್ತೆ.
No, Lord. Yesterday it was moved.
ಇದೇನ್ರಿ ನೋಡ್ರಿ ಮೆಮೊ, ನೆನ್ನೆ ಮೆಮೊದಲ್ಲಿ ಇದೆಯಾ?
ಸರಿ 177
ಹಾ.
ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರು ಅವರು. ನೀವು ಬೇರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಆಗಿದೆ ಅಲ್ವಾ ಇದು? ಆಗಿಲ್ವಾ ಒಂದ್ಸತಿನ?
ಇಲ್ಲ, ಹಾಕಿ ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ರು.
ಸರಿ ವಿಚಾರಿಸ್ತೀನಿ ಸರ್ ಬೆಳಿಗ್ಗೆ ಫೋನ್.
Why they are not listed? If it is not listed, let them list it. The end of the
Please.
ಅಲ್ಲ ನೆನ್ನೆ ಮೆಮೊ ಕೊಟ್ಟಿದಾರ ನಮ್ ಕೋರ್ಟ್ ಮುಂದೆ, ಮತ್ತೆ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅವರು? ಅಲ್ವಾ? ಮಾಡಿಫಿಕೇಶನ್ ನಮ್ ಮುಂದೆ ಬರಲ್ಲ.
ಅಲ್ಲ, by extending time.
ಮಾಡಿಫಿಕೇಶನ್ ಆರ್ಡರ್ ಅವ್ರ ಮುಂದೆನೆ ಹೋಗ್ಬೇಕು, ಆ ಜಡ್ಜ್ ಮುಂದೆ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು, ನಮ್ ಮುಂದೆ ಬರಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ ಬೆಳಿಗ್ಗೆ ಫೋನ್ ಮಾಡಿ.
ನಮ್ ಮುಂದೆ ಬರಲ್ಲ ಮಾಡಿಫಿಕೇಶನ್, ಆ ಜಡ್ಜ್ ಮುಂದೆನೆ ಹೋಗ್ಬೇಕು. ಅದಕ್ಕೆ ಹಾಕಿಲ್ಲ ಮೋಸ್ಟ್ಲಿ ನೋಡಿ ಅಲ್ಲ. ಅವ್ರು ಮತ್ತೆ ಬೇರೆ ಕೋರ್ಟ್ ಎಲ್ಲ ಮೂವ್ ಮಾಡ್ಲಿ, ಯಾರು ಆರ್ಡರ್ ಮಾಡ್ರ ಜಡ್ಜ್? ಕೊಡಿ ಮೆಮೊ ವಾಪಸ್ ಕೊಡಿ.
ಅಲ್ಲ, ಜಸ್ಟಿಸ್ ರಾಜೇಶ್ ಸರ್.
ರಚಯ್ ಸಾಹೇಬ್ರಿಗೆ ಇಲ್ಲಿಲ್ವಾ? ಬೆಂಚಲ್ಲಿ ಇದಾರ?
ಬೆಂಚಲ್ಲಿ ಇದ್ದಾರೆ.
ಇಲ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಬೆಂಚಲ್ಲಿ ಇದ್ದಾರೆ, ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಬೆಂಚಲ್ಲಿ ಇದ್ದಾರೆ.
ಬೆಂಚ್ ಇದ್ರೆ ಸಿಂಗಲ್ ಸಿಟ್ಟಿಂಗ್ ಮಾಡ್ಕೋತಾರೆ ಮೇಡಮ್. ಮಾಡಿಸ್ಕೋಬೇಕು, ಅಲ್ಲೇ ಮಾಡಿಸ್ಕೋಬೇಕು.
My lords, it's pertaining 304A. May be posted after vacations, my lords.
ಆಫ್ಟರ್ ವೆಕೇಶನ್?
Yes, my lords.
ನಮ್ ಮುಂದೆ ಬರಲ್ಲ. ಆ ಬಂದಾಗ ಯಾರ ಮುಂದೆ ಬರುತ್ತೋ ಆಗ ಮೂವ್ ಮಾಡಿ. ರೋಸ್ಟರ್ ನನ್ನ ರೋಸ್ಟರ್ ಕಂಟಿನ್ಯೂ ಆಗಲ್ಲ.
Mentioning from page number 7, 3031.
Serial number 30. So I received a NOC ವಕಾಲತ್ತು. I received a NOC ವಕಾಲತ್ತು.
ಆಯ್ತು.
Kindly after vacation.
ಹೇಳಿದಿರಾ ಧೀರೇಂದ್ರ ಎನ್ ಕಟ್ಟಿಗೆ ಹೇಳಿದಿರಾ?
ಹೇಳಿದ್ವಿ ಸರ್.
ಹೇಳಿದಿರಾ? ಯಾವಾಗ?
ನಿನ್ನೆ ಸಾಯಂಕಾಲ ಫೋನ್ ಮಾಡಿದ್ವಿ ಸರ್.
ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದಿರಾ ಅವರಿಗೆ?
ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ವಿ.
ಸುಳ್ಳು ಹೇಳ್ಕೊಡ್ದು. ಸುಳ್ಳು ಹೇಳಿ ನಾನು
ಕ್ಲೈಂಟ್
ನೀವ್ ಹೇಳೋದ್ರಲ್ಲೇ ಡೌಟ್ ಇದೆ ನಂಗೆ.
ಇಲ್ಲ, my client informed him.
ಕ್ಲೈಂಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡೋದ್ ಬೇಡ, ನೀವು ಮಾತನಾಡಿದಿರಾ ಈ ಲಾಯರ್ಗೆ ಧೀರೇಂದ್ರ ಎನ್ ಕಟ್ಟಿಗೆ?
I don't have ಫೋನ್ ನಂಬರ್. ನನ್ಗೆ ಯಾವ್ದು ಫೋನ್ ನಂಬರ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಮ್ ಕ್ಲೈಂಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಡೋಂಟ್ ಡೂ ಆಲ್ ದಿಸ್ ಕೌನ್ಸಿಲ್. ಡೋಂಟ್ ಟೆಲ್ ದಿ ಲೈ ಅಂಡ್ ಗೆಟ್ ದಿ ಇಲ್ಲ ಮಾಡೋದಿಲ್ಲ. ಬಿ ರೆಡಿ ಫಾರ್ ಅಡ್ಮಿಷನ್.
ಅಲ್ಲ
ನೋ ಕೌನ್ಸಿಲ್.
3 to 40.
Serial number 40 appear on the petitioner.
40
Kindly have the petition, madam.
ಏನಕ್ಕಿದೆ ಅದು?
Admission.
Inconvenience, senior inconvenience ಇದೆ ಆ ಕಾರಣಕ್ಕಾಗಿ.
ಮತ್ತೆ ಡೇಟ್ ಇದ್ಮೇಲೆ ಪೋಸ್ಟ್ ಆಯ್ತು ಮೇಡಮ್ ಇದು? ತಗೊಳ್ಳಿ. ಬೆಂಚ್ ಹಂಟಿಂಗ್
Yes, some inconvenience today.
ಏನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಹೇಳಿ? ವಾಟ್ ಇಸ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್?
ಹೊರಡ್ತಾರೆ.
ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್ ನಾನು ಓದಿನಿ, ಓದ್ಕೊಂಡು ಬಂದಿದ್ದೀನಿ, ಬಂದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಈ ಫಸ್ಟ್ ಇವೆಲ್ಲ ನಿಲ್ಲಿಸ್ಬೇಕು, ಈ ತರದ ಚಾಳಿಗಳೆಲ್ಲ.
41 to 46.
Serial number 46.
46 ಹೇಳಿ ಏನಾಗ್ಬೇಕು? ನೀವ್ ಯಾರಿಗೆ? SV ಪ್ರಕಾಶ್ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ? ತಗೊಳ್ಳಿ. Appellant counsel seeks time and counsel for the respondent also says no objection. ಅಲ್ಲ ರೀ 2007 ಮ್ಯಾಟ್ರು ಲಿಸ್ಟ್ ಆಗಿದೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಗೆ. ಒಂದ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳ್ತೀರಿ ನೀವು? ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್. ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಆಯ್ತು ಮಾಡಿ.
Orders matter serial number 1. Praveen C.
Amount pay ಮಾಡಿದ್ದೀನಿ. Kindly pass it over me.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಕಟ್ಟಿದ್ದೀನಿ.
Counsel for the petitioner would submit that he has paid the cost and filed memo for having deposited the cost. ಹೇಳಿ ಏನಾಗ್ಬೇಕು?
Kindly pass it
ಫೈನಲ್
over.
ಇಯರಿಂಗ್
ಅಲ್ಲಲ್ಲ ಅಡ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ. ಅಡ್ಮಿಷನ್
ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ವಾ?
ಅಡ್ಮಿಷನ್ ಗೆ ಅವರೇ ಟೈಮ್ ತಗೊಂಡ್ರು. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಸ್ ಬೀನ್ ಹರ್ಡ್ ಆನ್ ಮೈ ಪಾರ್ಟ್ 138 proceeding.
ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ವಾ ಇನ್ನು?
ಇಲ್ಲ ಇಲ್ಲ.
Post the matter immediately after summer vacation for admission.
ಡೇಟ್ ಮೇ ಬಿ 30th.
ಹಾ?
30th 30ನೇ.
ನಾನ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಯಾರು ಗೊತ್ತಿಲ್ಲ. ಕ್ರಿಮಿನಲ್ RP.
ಆಯ್ತು.
ರೋಸ್ಟರ್ ಬೆಂಚ್ ಬಂತೇನ್ರಿ ನೆಕ್ಸ್ಟ್? ಇನ್ನು ಬಂದಿಲ್ಲ. ಆಯ್ತು.
Serial number
ನಾವೇ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ಮೂವ್ ಮಾಡಿ.
ಅಲ್ಲ ಡೇಟ್ ಒಂದು ಮಾಡಿದ್ರು.
ಹಾ?
ಡೇಟ್ ಬಹಳ ಹಳೇದು ಹೋಗ್ತಾ ಇದೆ ಡೇಟ್.
ಏನ್ ಮಾಡೋದು?
ಒಂದು ಕೇಳ್ಕೊಳ್ಳೋದು
ನಾನ್ ಡೇಟ್ ಫಿಕ್ಸ್
ಅಲ್ಲ
ಮಾಡಲ್ಲ.
ತಾವಲ್ಲ ಯಾರಾದ್ರೂ ಬರ್ಲಿ 34ಕ್ಕೆ ಒಂದು ಹಾಕೊಳ್ಳಿ.
ಅಲ್ಲ ಆಯ್ತು, ನಾನ್ ಮುಂದಿನ ರೋಸ್ಟರ್ ಜಡ್ಜ್ ಡೇಟ್ ಫಿಕ್ಸ್
ಅಲ್ಲಲ್ಲ.
ಮಾಡಲ್ಲ.
ತಾವು ಯಾವ್ದಾದ್ರು ಒಂದು ಇದರಲ್ಲಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದು. ಇಲ್ಲ ಅದು ಬರೋದೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಎಷ್ಟು ಸಮಯ ಅಂತ
ನೀವ್ ಕೋರ್ಟಲ್ ಮೂವ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ ಜಡ್ಜ್ ಡೈಲಿ ಎಷ್ಟು ತಗೊಳ್ತಾರ ಗೊತ್ತಿಲ್ಲ,
I will
ಅಥವಾ
not
ಯಾವ
say-
ಮ್ಯಾಟರ್
I will not
ತಗೊಳ್ತಾರ ಗೊತ್ತಿಲ್ಲ.
anything.
ಐ ವಿಲ್ ನಾಟ್ ಫಿಕ್ಸ್ ದಿ ಡೇಟ್ ಫಾರ್ ದಿ
Yes,
ನೆಕ್ಸ್ಟ್
yes.
ರೋಸ್ಟರ್ ಜಡ್ಜ್.
ಎಸ್.
ಆಯ್ತು, ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾಗ.
serial number 2.
For the petitioner,
ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಪಿಟಿಷನರ್ ಅಂತಿದೆ.
for the petitioner in this matter, your lordships. Your lordships,
They have not complied the orders of this honorable court. He has not deposited the amount, my lord.
Learned counsel for petitioner has filed a memo for retirement along with a notice and acknowledgements. Considering the same, the memo for retirement is accepted. Learned counsel for the petitioner is permitted to retire from the case. Issue NBW against the petitioner.
may,
Jurisdictional police is directed to secure the presence of the accused petitioner and produce him before the learned magistrate.
may,
The warrant has been issued, my lord.
may I please, your lordships? I'm appearing for the petitioner in this matter. This matter was disposed of in the year 2019, 29 November 2019, your lordships, directing the petitioner to pay 50% of the amount, deposition of 50%.
Matter was disposed of.
Not disposed. IA disposed. of.
Yes, your lordships. My
Suspension of sentence order
suspend,
ಆಗಿದೆ. ಹಾ ಆಯ್ತು ಹೇಳಿ.
yes, your lordships. But thereafter, your lordships, petitioner paid 50% amount to the council on record. But however, he used it for his own
Counsel on
purposes.
record.
It is, yeah,
How
previous council
Huh?
on record. It
How
is the
they-
contention of the petitioner that he paid that 50% to the previous council on record. Thereafter, he did not deposit the amount and he has approached us after NBW has been issued. Petitioner is intending to settle the matter immediately. He is ready to pay the 50% deposition amount as directed by this honorable court back in 29th November 2019.
2019 ಅಲ್ಲಿ there was an order to deposit 50%
Yes, your
of the
lordships,
amount.
but thereafter, the previous council on record never contacted the petitioner, your lordships.
Hmm.
That's why there's a lapse in payment of the 50%.
Why the council has to contact? Is it not the duty of the
Even he
petitioner to
tried,
contact
even
an
he-
advocate? What happened in the
Very
case
true,
anta?
very true, your lordship.
Now then?
I agree, but even he contends that even he has tried to contact the.
One
council
breath
on
you are
record.
saying that the council on record was not contacted him. Another breath you are saying that
Yes,
amount was given to the
from
council and
both
council has not
Yes, your
deposited.
lordship, even the petitioner has tried to contact the council and the
Now
same
what
is,
happened, whether
I
the
have
warrant
also
has been
filed a
executed, warrant has been executed or not? Now
Your
who filed wakalat now?
Now I have filed my wakalatnama. It should put up after the board, your lordships. Yesterday I filed my wakalatnama, affidavit stating the same and 70 clause 2 to recall my warrant, your lordships.
For recalling the warrant, you have to make the payment 50% of the.
I'll make it today, your lordships.
You
If the
pay the
matter is
amount.
passed over, I'll definitely make the payment of 50% and the remaining 50%.
Council, this was the order passed in 2019.
I agree, your lordships, but since there was a communication gap between the previous
You
council on
proceed-
record
you
and the
proceed
petition.
against the petitioner.
We have proceeded, my lord. Now for that only they have come to this court.
Huh?
ಅವ್ರ ಅಗ್ನೆಸ್ಟ್ ಆಗಿ ಪ್ರೊಸೀಡ್ ಆಗಿದ್ದ ಸಲುವಾಗಿನೇ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಸಾಹೇಬ್.
ಈಗ ಏನಾಯ್ತು, ನೀವು ವಾರೆಂಟ್ ತಗೊಂಡ್ರ?
Warrant ತಗೊಂಡು ಹೋದಾಗ
2019 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ದು.
19. your lordship.
He has not complied with the order.
ಎಲ್ಲಾನು ಪೊಲೀಸ್
From 4 years, have you taken any steps?
ವಿ ಹ್ಯಾವ್ ಟೇಕನ್ ಮೈ ಲಾರ್ಡ್.
ಯಾವಾಗ ಏನಾಯ್ತು?
ಅದೇ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟ್ ಥ್ರೂ. ಆವಾಗ ಅವರು
ಯಾವ ಕೋರ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ವಿ?
ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್.
ಈ ಕೋರ್ಟ್ ಬಿಡ್ರಿ, ನೀವು 2019 24 ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
We have executed, we have taken steps before the trial court also, my lord.
ಏನಾಯ್ತು?
ಅದು
warrant ಏನಾಯ್ತು?
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು it has been
Why
kept.
this court has to issue warrant against him?
ಅದೇ they have not completed the orders of this court, my lord.
ಅದಕ್ಕೆ ಯಾಕೆ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಈ ವಾರೆಂಟ್ ಕೂಡ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿಲ್ಲ ಈಗ. ಈಗೇನು ವಕಾಲತ್ ಯಾವಾಗ ಬಂತು ಮೇಡಮ್ ಇದು? ಏನ್ ಹಾಕಿರೋದ?
Yes, your lord.
ತಗೊಳ್ಳಿ. ಏನಯ್ಯ? NBW ಹಾಕಿದ್ದಾರೆ ಅವರು NBW ವಾರೆಂಟ್ ಹಾಕಿದ್ರೆ ಅದಕ್ಕೆ ಮಾಡಿ. ಹಾ ತಗೊಳ್ಳಿ. The counsel for the petitioner has filed wakalat. Along with an application is filed to recall the warrant issued against the petitioner. And it is noticed by this court that an order was passed suspending the sentence on 29/11/2019. Subject to depositing of 50% of the fine amount. And the order is also very clear that if the amount is not deposited within 4 weeks, this order shall automatically stands vacated. And the counsel who appeared on behalf of the petitioner earlier filed a memo for retirement. And in spite of notice and acknowledgement also, the petitioner did not appear before the court and engage any counsel. And hence, the earlier counsel is permitted to retire from the case. Having taken note of the same, this court in view of non-compliance of the order in the previous occasion issued NBW against the petitioner, and the warrant has not been executed. And question of recalling the order of issuance of NBW doesn't arise, since he has not complied the order from 2019 for a period of 5 years. And hence IA is rejected. However, the liberty is given to the respondent to proceed against the respondent in accordance with law. Since the order of suspension of sentence is very clear that if the amount not been deposited within 4 weeks, order shall not be in force and automatically stands vacated. And hence, liberty is given to the respondent to proceed against the petitioner. ನೀವು ಹೋಗಿ ಅಲ್ಲಿ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವಿಲ್ಲಿ ವಾರೆಂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Please.
That is not correct order.
Grateful.
Three. Veerana Chikiti.
On submission, my lord. Memo is
Memo
filed.
for dismissal for the,
Please.
ನೆನ್ನೆ ಬಂದಿತ್ತಲ್ಲ ಇದೇನಾ?
Please, ಹೌದು.
ಹೇಳಿ.
ಇದರಲ್ಲಿ petitioner is present before the honorable court.
ಹಾ.
There is a shortage of amount.
Huh?
Shortage of amount. ಅವರು 3,50,000 ಕೊಡ್ಬೇಕಿತ್ತು.
Proceedings have settled the dispute out of the court. Therefore,
ಹೌದು.
it is settle ಆಗಿದೆಯಲ್ಲ ಇನ್ನೇನು?
ಅಲ್ಲ 3,50,000 ಕೊಡ್ಬೇಕಿತ್ತು. ಅವರಿಗೆ 2 lakhs ತಂದಿದ್ದಾರೆ. ಇನ್ನು 1.5 ಲಕ್ಷ ಕೊಡ್ಬೇಕು.
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನೀವು ಮೆಮೊ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಅದನ್ನ ಹೇಳಿ ಅಷ್ಟೇ. ನೀವ್ 2 ಲಕ್ಷ ತಂದಿರೋ 5 ಲಕ್ಷ ತಂದಿರಲ್ಲ.
Kindly grant,
ಬರ್ದಿರೋದು ಇಲ್ಲಿ
kindly grant
parties
one
to
more,
the above parties have settled their dispute out of the court ಅಂತ ಬರ್ದಿದ್ದೀರಿ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
kindly grant
Press
one more,
ಮಾಡ್ತೀರಾ ಇಲ್ವಾ?
one more accommodation.
ಒನ್ ಮೋರ್ ಅಕಾಮಡೇಷನ್ ಬಿಟ್ಬಿಡ್ರಿ, ಈ ಮೆಮೊ ಏನಾಗ್ಬೇಕು ಹೇಳ್ರಿ.
ಮತ್ತೆ ಮೆಮೋದ ಮೇಲೆನೆ we will report the settlement on the next date of hearing. June
Note.
1st week.
ತಗೊಳ್ಳಿ. The council has filed the memo stating that parties have settled the matter out of the court and prayed this court to dismiss the above petition. And now council contend that an opportunity has to be given since there is a short of money. And once memo is filed before the court that proceedings have been settled between the parties. And nothing is there to decide before the court, and hence in view of the memo, revision petition is dismissed.
One more recommendation. Please,
ಇನ್ನು ಕೊನೊಂದ್ ಆಟ ಆಡ್ತೀರಿ. ನೆನ್ನೆನೋ ಇತ್ತು, ಇವತ್ತೊಂದ್ರಿ,
Please.
ಇವತ್ ನೋಡ್ರಿ ಮತ್ತೆ ಇನ್ನೊಂದು.
I will withdraw the
Dismissed.
memo.
That's all.
I will file fresh,
Next,
4. A.
office objections.
submission.
Total memo moved.
ಅಲ್ಲ,
Without office objections complaints, why you have moved the? ಕೊಡಿ.
objection ಮಾಡಿದೀನಿ, ಅದು ಮ್ಯಾನ್ ಪಾಸ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಅಷ್ಟೇ. ಪೇಜ್ ನಂಬರ್ 5 ನಲ್ಲಿ 3 ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು, ನಾನು ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ, ಅದನ್ನ ಹ್ಯಾಂಡ್ ರಿಟನ್ ನಲ್ಲಿ ಫೈಲ್ ನೀವು ಹಾಕಿದೀರಿ ಅಂತ ಹೇಳಿ, ಟೈಪ್ ನಲ್ಲಿ ಹಾಕಿ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ರು. ದಟ್ ಇಸ್ ಆಲ್ಸೋ ಮಿಲಟ್ ಐ ಕೆಪ್ಟ್ ರೆಡಿ ಮಿಲಟ್.
Told. The council submits that is ready to file corrected copy of the revision petition. ಹೇಳಿ ಏನಾಗ್ಬೇಕು ಈಗ, ಏನಕ್ಕೆ move ಮಾಡಿದ್ದೀರಾ?
Suspension,
What is the
suspension of
absence?
sentence, Milord, 138.
Hmm.
But check amount, Milord, the trial court has ordered 6,15,000,
Hmm.
out of which 6,10,000 to the,
Hmm.
Milord, the.
What is your
complainant.
defense? What is your
My
defense?
defense is that, Milord, in fact, he was remained ex parte. And the check, Milord, the 138 itself will not attract because the check is bounced.
ಸರಿ, ನೀವು contest ಮಾಡಿಲ್ವಾ ಕೇಸ್?
ಅಲ್ಲಿ cross examination ನಿಲ್ಲಾಗಿದೆ.
ಮತ್ತೆ what is there to decide in revision
Milord,
petition?
I have also taken a ground that the one.
ನೀವು ಗ್ರೌಂಡ್ ಏನಾರು ತಗೊಳ್ರಿ, ವಾಟ್ ಇಸ್ ದೇರ್ ಟು ಡಿಸೈಡ್ ಇನ್ ಎ ರಿವಿಷನ್ ಒನ್ಸ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಕಂಟೆಸ್ಟೆಡ್ ದಿ ಮ್ಯಾಟರ್ ಅಂಡ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ದಿ ವಿಟ್ನೆಸ್.
I have also sought for a opportunity to
ವಾಟ್
remand the
ಅಪಾರ್ಚುನಿಟಿ?
case and
Ah.
also let
ಯಾವ
the,
ವರ್ಷದ ಕೇಸ್ ಇದು?
let it is of the year.
2021.
ಹೌದು.
ಹಾ,
And the 138 itself, it will not attract ಅಂತ ಹೇಳಿ.
ಅದನ್ನ ನೀವು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಕಂಟೆಸ್ಟ್ ಮಾಡಿದವ್ರು ನಾವೇನ್ ಡಿಸೈಡ್ ಮಾಡೋಣ ಇಲ್ಲಿ ವೆದರ್ ಇಟ್ ಅಟ್ರಾಕ್ಟ್ಸ್ 138 ಆರ್ ನಾಟ್ ಅಂತ.
I understand,
ಹಾ, ರಿವಿಷನ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡೋದು?
I understand.
Revision only if an order suffers
That's
from its
perfectly
legality and correctness. Illegality and correctness ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ. What is there to decide?
Go down. I
Go down ಇಟ್ಕೊಂಡು ನಾನೇನ್ ಮಾಡೋದು ಇಲ್ಲಿ? I have to decide the revision petition in accordance with law. Told. This matter is listed for orders and heard the petitioner counsel. And counsel filed an application for suspension of sentence. And on perusal of the material available on record, this petitioner has not contested the matter.
You
before the
lost
trial
me
court.
kindly. May I request, Milord?
And when the case of complainant is not countered by the revision petitioner and nothing is there to decide in revision petition. And now he cannot contend that the check is not towards the recovery of debt or liability. And once such defense is not taken before the court, nothing is there to decide in the revision petition.
Milord, you lost me kindly.
The jurisdiction of this court is to consider whether the order impugned suffers from its legality and correctness. When there is no defense at all, and also no probable case is made out before the trial court, and nothing is there to decide in the revision, and hence I do not find any ground to entertain the
may-
revision petition, and hence revision petition is
May,
dismissed.
may I make one submission, Milord?
ಹೇಳಿ ಏನ್?
You lost me kindly, Milord. ಹಂಗ್ ಮಾಡಿದ್ರೆ ತೊಂದ್ರೆ. You lost me kindly.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ?
Milord, my submission, it's a.
ರಿವಿಷನ್ ಈಗ 5,000 ಇದೆ, ಇನ್ನೊಂದ್ 10,000 ಮಾಡಿ ಈ ತರದ ಕೇಸ್ಗಳನ್ನೆಲ್ಲ ಇಟ್ಕೊಂಡು ಅಂತ.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಸ್ವಾಮಿ. ಒಂದೇ, Milord, the 138, Milord, the check.
ನೀವು ಕೇಸ್ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಫಸ್ಟ್ ಓನ್ಲಿ ಟೂ ಆಪ್ಷನ್ಸ್.
It's taking,
One is rebuttable presumption. You have to rebut your case
Yes.
either in the cross examination of PW1 or by leading your defense evidence.
Yes.
Both is not there before the court.
Milord,
Then why court has to
No, no.
entertain the revision?
my contention is not only that.
Ah.
Milord, my contention, you lost me, bear with me for a minute, Milord.
Hmm.
My contention before the, Milord, even in the absence of a contention, 138, the ingredients itself will not attract, Milord, because it has been bounced on the ground that account blocked situation covered under 21-25. That situation arises where the check has been, Milord, the account has been blocked by the court order or by the defreeze. And, Milord, it is an attachment by the court order. The such occasions, Milord, the 138 will attract. the Gujarat High Court, Delhi High Court, and Kerala High Court, have quashed the proceedings.
If I have passed an order, you are
Kindly,
approved by the order, you can take
You
it
are-
elsewhere.
Allah, for
Gujarat High Court garu ತಗೊಂಡೋಗಿ ಯಾವ
this court has also in a similar situation have held, similar situation.
ಆ ಬೆಂಚ್ ಮುಂದೆಲ್ಲ ತಗೊಂಡೋಗಿ
You lost me. Kindly may not,
legal order pass ಮಾಡಿದೀನಿ according to me,
ಅಲ್ಲ,
it is a
admission
legal
statement.
order, you can take it elsewhere.
Allah,
That's all.
admission statement.
That's all, counsel.
My only
No, no,
request,
no, counsel.
Let-
ಬೇರೆಯವರೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ನಾನ್ ಮಾಡಕ್ ಇಲ್ಲಿ ಕೂತಿಲ್ಲ ಆಯ್ತಾ.
you last may at least to call after vacation.
No, I have already passed an order, that's all. Next,
Serial number 5.
That is without issuing, kindly.
why
See
should
my
the court has to
situation.
issue notice, not a case for even issuance of notice also.
Let,
Why?
Only,
You are not contested the matter.
let I have,
Ah.
in the reply, let I have given,
Reply ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
reply,
ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡು?
let kindly
counsel.
may not do it.
No,
Let-
counsel. Nothing is there to decide in a revision petition.
I'm only requesting, only one request.
ನಾ ಹೇಳಿದ್ನ ಆಗೋಯ್ತು, ಆರ್ಡರ್ ಬರ್ದಿದ್ದು ನಾನು ರಿಟೈಲ್ ಆರ್ಡರ್, ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ನಿಮ್ಗೆ. ಏನಾರು ಇದೆಯಾ ಡಿಸೈಡ್ ಮಾಡಕ್ಕೆ ಅಂತ ರಿವಿಷನ್ ಅಲ್ಲಿ? Nothing is there to decide in
Let,
revision.
my submission, taking of cognizance itself, it is bad, it's not 138. That legal ground is available even under the
Cognizance
revision jurisdiction.
ತಗೊಂಡಾಗ್ಲೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು, ನಾಟ್ ಆನ್ ಫೈನಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆದಾಗಲ್ಲ.
Allah, if the 138 itself, it will not attract, even in the absence of, it's a legal lacuna.
ನಾನೀಗ ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀನಿ,
ಅಲ್ಲ,
you can take
my-
elsewhere.
My request,
Counsel. Yes, next matter ಕರೀರಿ ಮೇಡಮ್.
5. Santosh Kumar.
Awaiting police report in respect of notice issued to the respondent.
Preparing
Ah.
for the respondent.
Both the parties are present, my lords.
Respondent ko akalat file ಮಾಡ್ತೀನಿ.
Both the parties are present and matter has been settled, my lords.
Hmm.
Filing joint memo along with joint affidavit.
Third,
Both the parties are present.
counsel Sri, ಯಾರ್ respondent ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದು?
ಶಿವಾನಂದ R.
Shivanand has filed ವಕಾಲತ್ for respondent. ಕೊಡಿ ಏನಾಯ್ತು?
Filed joint memo and also joint
Both the
affidavit.
parties are present before the court and filed the application under section 147 of Negotiable Instrument Act. And both parties as well as the respective counsels have also signed the application. And apart from that, they have also filed joint affidavit. In terms of the joint affidavit, ಏನ್ settlement ಏನ್ರಿ?
1 ಲಕ್ಷ settle ಆಯ್ತು.
Hmm?
1 ಲಕ್ಷದ್ದು.
Matter has been settled for an amount of rupees 1 lakh. And respondent has received an amount of rupees 1 lakh and has executed a loan release agreement.
Also,
ಎಲ್ಲಿದೆ ಅದು? Loan release agreement.
ಸುಮೀಲ್ ಒಂದು. ಮೇಡಮ್.
And matter is settled for full and final settlement.
yes.
In view of the application and joint development, joint affidavit filed by the parties and releasing of the loan release agreement. ಏನಾರು ಸೆಂಟೆನ್ಸ್ ಇದೆಯಾ ಅಥವಾ ಡಿಫಾಲ್ಟ್ ಸೆಂಟೆನ್ಸ್?
Default
Default sentence ಇದೆ ಅಷ್ಟೇ.
IA is allowed and
In the case of default, he shall undergo.
and
simple
also sentence is a default sentence. ಈ 10,000 ಕೊಟ್ಟವ್ರ ಯಾರು ಮತ್ತೆ? ನೀವೇ ರಾಜಿ ಮಾಡ್ಕೊಬಿಟ್ರೆ ಕೋರ್ಟಿಗೆ ಸರ್ಕಾರಕ್ಕೆ 10,000 ಕೊಟ್ಬೇಕಲ್ಲ, 16 ಕೊಟ್ಟವ್ರು. ಅಕ್ಯೂಸ್ ಯಾರು ನೀವಾ? ನೀವು
Yes.
ಕಟ್ಬೇಕಲ್ಲ 10,000. Remaining amount of which 10,000 shall be defrayed to the state. ಕೋರ್ಟ್ ಕಾಸ್ಟ್ ಕಟ್ಟೋರ್ ಯಾರ್ರಿ?
Accused ಕಟ್ಬೇಕು.
ಆ?
Accused ಕಟ್ಬೇಕು.
ಕಟ್ಟಿ ಮತ್ತೆ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಈಗ? ಕಟ್ ಬರ್ತೀರಾ ಅಥವಾ
I'll pay it,
ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಕಟ್ತೀರಾ?
I'll pay it before the magistrate itself, my lords.
ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟಲ್ಲೇ ಕಟ್ಬೇಕು
Please.
within 1 week.
Along with this,
And application is allowed and there is no any need of acquittal order since the sentence is default sentence. However, the trial court has imposed the cost of rupees 10,000 and the same shall be defrayed out of the compensation amount and in lieu of settlement arranged between the parties, the petitioner is given 1 week time to pay the fine amount of rupees 10,000 before the magistrate and produce the receipt within 2 weeks before the registry for having deposited the amount of rupees 10,000. If no such payment is made, order to recover the same in accordance with law. ಮಾಡಿ ಕಟ್ಟಿ ದ್ವಾರ ಬಿಟ್ಟು ವಾರದೊಳಗೆ ಕಟ್ಟಿ. Disposed of, within it.
6. Sudhaji.
In this case, my lord, only minor objections. ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಎಂಟರ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಹಾಕಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಲಿಮಿಟೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಎಂಟರ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಹಾಕಿಲ್ಲ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್.
Number of delay days to be mentioned in the.
Number of delay days ಮಾಡಿಲ್ಲ.
6 days.
ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ?
ಇಲ್ಲ ಸರ್.
ಫುಲ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಹಾಕಿಲ್ಲ. ಏನ್ ಐಎ ಇದೆಯಾ? ಐಎ ಇದೆಯಾ ಮೇನ್ ಪಿಟಿಷನ್?
ಐಎ ಗೇಮ್ ಸರ್. ಐಎ 2. ಮತ್ತೆ 206 days.
ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಹಾಕಿ ಫುಲ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಹಾಕಿ ಡಿಲೇ ಮೆನ್ಷನ್ ಮಾಡಿ
ಇವತ್ತೇ ರೆಡಿ ಇದೆ.
ಇವತ್ತೇನ್ ರೆಡಿ ಮಾಡ್ತೀರಿ? ತೊಗೊಳ್ಳಿ. Petitioner is given 1 week time to comply with office objection. Next,
7. Krishnamurthy N.
Krishnamurthy N. Office objections.
Petition, 7 objections are raised by the office.
ಎಷ್ಟಿದೆ?
Within a week, 7 objections ಇದೆ, minor objections.
Council,
Within a week, I'll have it.
Council 6, 1 week time to
Please.
comply with office objections.
8.
Rajesh P.
Rajesh P.
Petition, my lord.
We filed an IA, my lord.
Office objections ಕೇಳ್ರಿ.
Comply ಮಾಡಿದೀನಿ sir.
ಯಾವಾಗ?
Last time
ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಮತ್ತಿದೆ ನೋಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
Objection.
6 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಇನ್ನು.
ಇಲ್ಲ ಎಲ್ಲ ಮಾಡಿದೀನಿ sir.
ಎಷ್ಟ್ ದಿವಸ ಬೇಕು ಹೇಳ್ರಿ? ಅಲ್ಲಿದೆ 6.
ಇಲ್ಲ ಎಲ್ಲ ಮಾಡಿ ಇದ್ ಮಾಡಿದೀನಿ ಸೈನ್ ಮಾಡಿ.
ಕೌನ್ಸಿಲ್ ನೆನ್ನೆನೂ ಹೀಗೆ ಮಾಡಿದ್ರು ಒಬ್ರು ಲಾಯರ್ ಮಾಡಿದೀನಿ ಅಂತ 10,000 ರೂಪಾಯಿ ದಂಡ ಹಾಕಿದ್ದೆ, ಆಮೇಲೆ ಕೊನೆಗೆ 5,000 ಮಾಡಿದೆ, ಕೊನೆಗೆ ಮತ್ತೆ 2,000 ಮಾಡೀನಿ. ಈಗ ನಿಮ್ಗೂ ಅದು 2,000 ಹಾಕ್ಬೇಕಾ ತಾವೇನು? ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಬಂದಿರೋದೇ ಫಸ್ಟ್ ಟೈಮ್. 6 ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ, ನೀವು ನಾನು ಕಂಪ್ಲೈ ಮಾಡಿದೀನಿ ಅಂತೀರಿ. ಯಾವಾಗ ಕಂಪ್ಲೈ ಮಾಡಿದಿರಿ?
ಅಲ್ಲ ಮೊನ್ನೆ ಎಲ್ಲ ರೀಡ್ ಮಾಡಿ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇನ್ನು ಅದನ್ನ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿ ಬರಿತೀನಿ, ಅದನ್ನ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಟೈಮ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ.
ಕಸ್ಟಡಿ ಇದಾರೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ.
ಕಸ್ಟಡಿಲಿ
ಇದಾರಪ್ಪ ಇವರು.
ಕಸ್ಟಡಿಲಿ ಇದ್ಮೇಲೆ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲ, ಹೋಗಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಾದ್ರು ಇದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಎಲ್ಲ ಮಾಡಿದೀನಿ ಸರ್, ಮಾಡಿದೀನಿ ನಾನು ಮೆಮೊ ಮಾಡಿರೋದು. ಎಲ್ಲ ಮಾಡಿ ಮೆಮೊ ಮಾಡಿದೀನಿ ಸರ್.
ಕಂಪ್ಲೈ ಏನಾರು ಮಾಡಿದಾರೇನ್ರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ಮೇಲೆ? ತಗೊಳ್ಳಿ. The counsel for the petitioner submits that he has complied with office objections. And on verification, there are 6 office objections. ಕೊಡಿ. ಇದೇನಿದೆ ಇಲ್ಲೇ ನಾವು ನೋಡಿದ್ರಲ್ಲ. And office objection is that partly complied with. And at serial number 1, 4, 5 and 6 are not complied with. And hence directed to comply with the office objections within 1 week. Next.
9.
Only my lord's age is my lord of the 43, my lords. I have mentioned 40, my lord's age. Petitioner
Age
says-
ಒಂದೇನಾ?
ಅದು ಒಂದು my lords, ಇನ್ನೊಂದು small special judge ಅಂತ.
ಎಷ್ಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಹೇಳಿ?
Only 2, my lords. Yeah, both are my lords small.
Age to be mentioned correctly. Whole name to be mentioned correctly.
Lord, special judge ಅಂತ ಬರಿಬೇಕು ಅಷ್ಟೇ.
That's para number 1.
ಸಿಟಿ ಸಿವಿಲ್ ಅಂಡ್ ಸೆಷನ್ ಜಡ್ಜ್ ಅಂತ ಬರ್ದೇನೆ, ಸಿಟಿ ಸಿವಿಲ್ ಅಂಡ್ ಸೆಷನ್ ಸ್ಪೆಷಲ್ ಜಡ್ಜ್ ಅಂತ ಬರಿ.
ಆಗ್ಬೇಕಿತ್ತು. ಆಯ್ತು. Petitioner counsel is permitted to correctly mention the
ಏಜ್ ಅಂಡ್
court name
yes.
and also the age. ಹೇಳಿ ಏನ್ ಮ್ಯಾಟರ್ ಅನ್ನು ಹೇಳಿ.
In this matter, I have sought for the defreezing of the fixed deposits. The respondent police the falsely show that is FD account number. Page number 48 may I take? Page number 48. Lord, this is not the last two lines, not that is SB account number, Lord.
ಪೊಲೀಸ್ ನೋಟಿಸ್ ಅಂತ ಏನೋ ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಆ
ಹಾ.
police 91 ಅಲ್ಲಿ Lord, they intimated to the bank to Lord the freeze the account of this petitioner.
Hmm.
Lord, they have shown Lord last two.
ಏನ್ ಫ್ರೀಸ್ ಆಗಿದೆಯಾ ನಿಮ್ಮ ಅಕೌಂಟ್?
ರಿಲೀಸ್ ಆಗಿದೆ, ಫ್ರೀಸ್ ಆಗಿತ್ತು, ರಿಲೀಸ್ ಆಗಿದೆ. ಬಟ್ Lord, along with that,
ಫ್ರೀಸ್ ಆಗಿದ್ದು ಡಿಫ್ರೀಸ್ ಆಗಿದೆ.
ಹೌದು ಡಿಫ್ರೀಸ್ ಆಗಿದೆ.
ಈಗ ಮತ್ತೇನ್ ನಿಮ್ ಪ್ರೇಯರ್?
Lord, the problem is this Lord. They have shown Lord the FD account number instead of SB account number. Lord, the bank has Lord the not only Lord the freeze the SB account number, also Lord along with all fixed deposits.
ಆಯ್ತು, ನೀವು ಡಿಫ್ರೀಸ್ ಆರ್ಡರ್ ಯಾವ್ದಾವ್ದು ಕೇಳಿದ್ರಿ?
Yes, Lord, I will take
ಕೆಳಗಿನ
Lord.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದು ಕೇಳಿದ್ರಿ ಡಿಫ್ರೀಸ್?
Lord, page number 52, Lord.
Yeah.
They have sought for Lord the defreezing of the account, Lord the honorable court directed to Lord the defreeze the account.
ನೀವೇನ್ ಕೇಳಿದ್ರಿ ಅದನ್ನ ಮಾಡಿದಾರ ಆರ್ಡರ್?
ಮಾಡಿದ್ದಾರೆ, but fixed deposit ಬ್ಯಾಂಕ್ ನವರು ಅದನ್ನ ಡಿಫ್ರೀಸ್ ಫ್ರೀಸ್ ಮಾಡ್ತಾರೆ.
ನೀವು ಅದಕ್ಕೆ ಕೇಳ್ಬೇಕಿತ್ತು ಆರ್ಡರ್.
ಅದನ್ನ ನಾನು ಐ ವಿಲ್ ಟೇಕ್ Lord to the
ನೀವು ಅದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕು ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಹಾಕಿದೀನಿ, ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ರಿಜೆಕ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಪೇಜ್ ನಂಬರ್ Lord, page number 21 Lord. Page number 21.
21. ಹಾ.
Before that, I could take my lords to that page number 21. I will take my lords to the page number 48, my lords. 48. FD account number ತೋರಿಸ್ತಾ ಇರೋದು ಅವರು
48.
48 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಟು ಲೈನ್ಸ್ ಅಲ್ಲಿ
ಹಾ.
ನೋಡಿ FD ಫಿಕ್ಸ್ಡ್ ಡಿಪಾಸಿಟ್ ಅಕೌಂಟ್ ನೋಡಿ
ಫಿಕ್ಸ್ ಡೆಪಾಸಿಟ್ ಅಕೌಂಟ್
ಅಕೌಂಟ್
ನಂಬರ್
ನಂಬರ್
ಅಂತ
ತೋರಿಸ್ತಾರೆ.
ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಅವ್ರು ಕೇಳಿದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ,
ಹೇಳಿದ್ದಾರೆ.
ಆಕ್ಚುಲಿ ಮಾಡೋದು ದಟ್ ಇಸ್ ನಾಟ್ FD ಅಕೌಂಟ್, ದಟ್ ಇಸ್ SB ಅಕೌಂಟ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮಾಡೋದು ದಿ 49 kindly please. What the bank did is freeze freeze the not only that account along with fixed deposits.
ಎಲ್ಲಿದೆ ಅದು?
ಅದು next page 49.
We have hereby informed you that we have freezed the account numbers also.
Police only
All the fixed deposits
Yes.
linked to the account.
police only
account
sought to
number. ಹಾ.
police only sought to freeze this account by showing PF. The bank also along with that the account other fixed deposits also the freeze.
ಆಯ್ತು, that is the
Then,
reason,
then-
that
then
is the reason only
Yes, Lord. Then
defreeze order has been
Yes,
passed in respect of the other bank accounts.
afterwards page number 61 I approached the bank.
ಫಿಕ್ಸ್ ಡೆಪಾಸಿಟ್ ಗೆ ಅವ್ರ ಪ್ರೇಯರ್ ಇದೆ, ಹೌದಾ?
Fixed deposit
ಫಿಕ್ಸ್ ಇಲ್ಲಿ ಇರೋದು ಅಕೌಂಟ್ ನಂಬರ್ ಇರೋದು ಫಿಕ್ಸ್ಡ್ ಅಕೌಂಟ್ ನಂಬರ್.
ಅದು SB account
ಅದು SB account.
wrongly shown they have
ಆಯ್ತು.
wrongly shown.
ಹಾ.
even though the police the
ಬ್ಯಾಂಕ್ ಯಾರು ಎಫ್ಐಆರ್ ಆಗೋದು? ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ಬ್ಯಾಂಕಿಗೆ?
ಅಲ್ಲ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರೇ they the wrongly mentioned that FD account and shown the PF which has been ordered to release. That along with that account the FD accounts also seized by the bank. And I have given a letter page number 61 to the bank. Page number may I take 61
ಅಲ್ಲ ರೀ, why you have, your request is only for
seizing the
particular account number. ಹೌದಲ್ಲ? Freezing. Then why the bank has communicated to the police sub-inspector
Properties are required for,
and all the fixed deposit links to the account number ಅಂತಿದೆ.
because all the properties are,
Huh?
all the properties are required for the identification. All the properties are required for identification.
ಸರಿ ರೀ, ಅವ್ರ ಪ್ರೇಯರ್ ಇರೋದು ಓನ್ಲಿ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಏನಿದೆಯೋ ಅದ್ ಮಾತ್ರ. FD ಅಕೌಂಟ್ಸ್ ಎಲ್ಲ ಯಾಕೆ ಮಾಡ್ಬೇಕು? ನಿಮ್ ರಿಕ್ವೆಸ್ಟ್ ಇರೋದೆ ಪೇಜ್ ನಂಬರ್ 48 ಅಲ್ಲಿ.
48.
Though it is mentioned as fixed deposit ಅಂತ ಮಾಡಿದ್ರು ಕೂಡ ಅಕೌಂಟ್ ನಂಬರ್ SB ಅಕೌಂಟ್ ನಂಬರ್ 132. Why the bank has freezed all other fixed deposits also? No prayer at all.
Only account numbers is
132.
132.
ಈಗ now that is also defreezed.
Please,
You have the order passed by the trial court. ಹಾ.
please.
fixed they have freezed fixed deposits also now the even I have
HCGP is directed to take notice and get the instructions and list this matter on 14th.
Please.
14 ನಮ್ದೇ ಬೆಂಚ್ ಇರುತ್ತೆ, ಅದ್ ನೋಡಿ ಅಷ್ಟೊಳಗೆ
permitted to correct the age.
ಕೊಟ್ನ ಪರ್ಮಿಷನ್. ಪರ್ಮಿಟೆಡ್ ಟು ಅಂತ ಮಾಡಿದ್ವಲ್ಲ ಮೇಡಮ್, ಕಂಪ್ಲೈನ್ಸ್. ಹಾ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡ್ತೇನೆ. ಒಂದು ಏಜ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಮತ್ತೆ ಪ್ರೇಯರ್
ಎಷ್ಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್
ಮೂರು ಇದೆ.
ಹಾ, ಏನೇನದು?
ಒಂದು ಏಜ್,
ಹಾ,
ಮತ್ತೊಂದು ಸೀರಿಯಲ್ ನಂಬರ್, ಮತ್ತೊಂದು ಐಎ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಸೆಷನ್ ಕೋರ್ಟ್ ಇದು ಮೆನ್ಷನ್
ಏನ್ರಿ ನಾವ್ ಮಾಡಕ್ ಕೆಲ್ಸನ ನೀವ್ ಅಲ್ಲಿ ಹೋಗಿ ಕ್ಲರಿಕಲ್ ಕೆಲಸ ಮಾಡೋದನ್ನ
ಕೊಡಲ್ಲ
ಕೊಡಲ್ಲ
sir.
ಮಾಡ್ಬೇಕು.
ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಕೊಡಲ್ಲ, ಕೋರ್ಟ್
ಯಾಕ್ ಕೊಡೋದಿಲ್ಲ? ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೈಸ್
ಅಲ್ಲ
ಮಾಡಿದಾಗ
ಕೋರ್ಟ್ ಬಂದ್ಮೇಲೆ ಕೊಡ್ತೇವೆ ಅಂತ ಹೇಳಿ.
ಮತ್ತೆ ನಾವಿಲ್ಲಿ ಕೂತ್ಕೊಂಡು
I'm
ಕೆಲಸ
ready to-
ಮಾಡೋಣ.
ನಾನು ಈಗ
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 4 2 ಸರಿ ಹಾಕಿದಿರಿ.
ಹೌದು sir, ಹೌದು
ಹಾ,
sir.
ಆಮೇಲೆ
ಸೀರಿಯಲ್ ನಂಬರ್ ಒಂದು ಏಜ್ 49 ಅಲ್ಲಿ 50 ಬರುತ್ತೆ.
ಐಎ ಪ್ರೇಯರ್ ಏನಿದೆ?
ಐಎ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಸೆಷನ್ ಕೋರ್ಟ್ ಇದು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ.
ಸಸ್ಪೆಂಡ್ ದಿ ಸೆಂಟೆನ್ಸ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ತೀರಿ ಅಷ್ಟೇನೆ. ಹಾ,
ಸೆಷನ್ ಕೋರ್ಟ್ ಇದು ಬರೀತೇನೆ ಸರ್.
CCC 311/2020. ಆಮೇಲೆ ಇನ್ನೊಂದ್ ಯಾವ್ದು ಮೇಡಮ್?
ಸರ್ ರೆಡಿ ಇದೆ.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ್ರಿ ಇದು? 138.
138.
ಹಾ, ಪ್ರೇಯರ್ ಸರಿ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ಪ್ಲೀಸ್ ಟು ಸಸ್ಪೆಂಡ್ ದಿ ಸೆಂಟೆನ್ಸ್ ಅಂತಿದೆ. ಹಾ, ಆರ್ಡರ್ ಅಂಡ್ ಅಫೆನ್ಸಸ್ ಸರ್. ಅಫೆನ್ಸ್ ಬರ್ದಿಲ್ಲ ಅಂತ ನೋಡ್ರಿ. Petitioner counsel is permitted to comply with office objections during the course of the day. ಏನ್ ಹೇಳ್ರಿ?
One section 138.
ಹಾ,
The check amount is 1,85,000. The court below has convicted for
what is your defense before the trial court?
defense. He has, in the respondent not mentioned in demand notice about the demand promissory note. Further, the check was issued on 18/11/2019.
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೋಟಿಸ್ ಜಾರಿಯಾಗಿದೆ. You have not given reply. Have you cross examined the PW1?
Yes.
ಎಲ್ಲಿದೆ?
Nanತರ check was Vijaya Bank. At that time it was merged with the Bank of Baroda. Your Honor.
ಇದೆಲ್ಲ ಬಿಟ್ರಿ, what is your defense in the cross examination of PW1?
He has no financial capacity to earlier he has and he has no license to lending the business here. I have mentioned the respondent financial capacity lend money 1,80,000. He has not stated the source of money. Further, he has not produced any passbook to show that he has sufficient money. Demand promissory note lending carries 18% interest. The respondent lended money on 2/11/2019, but check collected money was 18/11/29. While collecting the check for the loan amount, the respondent has not collected the interest. Complainant has not stated the place of transaction. Not complied the provision of section 269 as Income Tax Act.
Good. Heard the petition of counsel and also consider in the ground surgery the petition. Sentence is suspended subject to making payment of 50% of the fine amount. And also directed to execute a bond for ₹50,000 with one surety within 4 weeks. ಮೇಲ್ಗಡೆದು 4 weeks madam, same order. And if ಅಲ್ಲ ಒಂದು sentence ಸೇರಿಸ್ಕೊಬಿಡಿ. If not complied within 4 weeks, this order stands automatically vacated ಅಂತ ಹಾಕ್ಬಿಡಿ ಮೇಲೆ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ. ಮತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಬರೀ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಬರ್ತಾರೆ ಅಪ್ಲಿಕೇಶನ್ ದಿನ ಅದೇ ಕೆಲಸ.
I may permit to comply there.
Comply,
Office objection.
given permission to comply.
12. Somraju.
ಯಾವ್ದು ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ಮೇಡಮ್ 11?
11.
My lord, I pray for time, my lord, for compliance, with the liberty to move
ಎಷ್ಟು ದಿವಸ ಬೇಕು?
within 2 days, madam.
Council seeks 2 days time to comply with office
With the
objections.
liberty to move the vacation.
Granted
bench.
as sought.
With the liberty to move vacation bench.
ಮೂವ್ ಮಾಡಿ, ಎಲ್ಲ ಹೋಗಿ ಮೂವ್ ಮಾಡಿ.
Obligation.
12.
ಸೋಮರಾಜ್,
1 week time.
1 week time granted as sought.
30.
Sundar Raj,
Should may kindly grant me a week time. I will complete.
week's time granted as sought.
Please.
14. Vijay M.
Vijaya MN,
For appellant, my lord, in this case, there are 4 office objections, my lord,
ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ?
1 week.
1 week time granted as sought.
50.
Please see. Non-compliance of office objection second time. In spite of matter listed for second time for non-compliance, not complied, and hence 2 weeks time granted. Comply the same.
60.
For the
A one substituted service of notice in respect of R1 A to G, A and G. Paper publication ಈಗ ಹಾಕಿದಾರ?
packaging, sir.
IA 1 of 20.
Heard on IA number 1/24 wherein prayer is made to take out the notice by substituted service of notice in respect of R1 A and R1 G. And for the reasons stated in the accompanying application and affidavit, ಯಾವ್ದು paper ಯಾವ್ದು?
Samyukta Karnataka,
Bangalore.
Bangalore edition.
Permitted to take out the notice in Samyukta Karnataka Bangalore edition.
Yes,
And take out the notice on or before. ಕೊಡಿ. ಇಲ್ಲ ಮತ್ತೊಂದ್ ತಿಂಗಳು ಕಾಯ್ಬೇಕು.
25. 25 ಅದ್ ತಗೊಳಕ್ಕೆ. ಆಮೇಲೆ ಬೇರೆ
ತಗೊಳಕ್ ಯಾಕೆ 25 ಮೇಡಮ್? 3 ವಾರ ಹಾಕ್ಬೇಕು ತಗೊಳಕ್ಕೆ? ಇವತ್ತೆಷ್ಟು ಡೇಟ್?
25.
ಮತ್ತೆ ಮೇ 20 ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀರಿ? ಮುಂಚೆನೆ ಕೊಡಿ. 10 days ಅಲ್ಲಿ ತಗೊಳ್ಳಿ.
ಸರ್ ನಾನ್ ತಗೊಳ್ತೀನಿ. ತೊಂದ್ರೆ ಏನಂದ್ರೆ
ಹಾ?
ಸ್ಟಾಫ್ ಮೇ ಬಿ ರಿಪೀಟೆಡ್ ಸ್ಟಾಫ್ ಇರ್ತಾರೆ ಅದಕ್ಕೋಸ್ಕರ.
ಎಲ್ಲಿ?
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ
ನಿಮ್ಗೆ ಅದಕ್ಕೆ ಯಾಕೆ ಚಿಂತೆ? ಹೈಕೋರ್ಟ್ ಏನ್ ಮುಚ್ಕೊಂಡು ಹೋಗಲ್ಲ.
ಇಲ್ಲ
ಹಾ
13.
13/5
Next hearing date
and for date of appearance
14/6.
14/6.
right.
Hearing on IA 70. Yes, Ravindra Holla.
under section 138.
Additional evidence documents filed by the petitioner
ಏನಾಗಿದೆ?
counsel.
During the pendency of Malad the CC, Malad these
IA
judgments has.
IA will be considered along with
Please.
main petition.
Please.
Millet's
Eight minutes.
case, yes, filed an application under three ninety-one.
ಅದೇ,
ಏನ್
it will be
admission
considered.
admission ಆಗಿದೆಯಾ?
Admission ಆಗಿ.
ಆಗಿದೆ ಎಲ್ಲ ಆಗಿತ್ತು ಸುಮ್ಮನೆ ಸಸ್ಪೆಂಡ್.
Final hearing ಬರ್ಬೇಕಾ?
ಅದೇ,
ಏನಕ್ಕೆ ಬರ್ಬೇಕು?
Final hearing
Post of-
ಬರ್ಬೇಕು.
ಆಯ್ತು. List the matter for.
IA is not maintainable, that is my sufficient.
ಆಯ್ತು.
please.
IA will be considered along with main petition ಅಂತ ಹಾಕಿದೀನಿ.
ಸರಿ,
ಆಯ್ತು.
ಸರಿ,
List the matter immediately after summer vacation.
please.
80.
One minute.
ಹೇಳ್ರಿ suspension of sentence. ಈಗೇನ್ ಅರ್ಜೆಂಟ್ 21 matter
Urgency ಇಲ್ಲ, my lord, it was listed automatically.
listed automatically. ನಿಮ್ಗೂ ಬೇಕಾಗಿಲ್ಲ suspension of sentence ಹೌದಾ?
ಆತರ ಇಲ್ಲ, my lord. Already.
21 ಅಲ್ಲಿ ಹಾಕ್ಯಾರ 21 ಅಲ್ಲಿ.
10% he has deposited already. Already 10% he has deposited, my lord. He is in
Percent.
very bad condition, bedridden.
ಏನ್ ಗ್ರೌಂಡ್ ಏನ್ ನೀವೇನು ಎವಿಡೆನ್ಸ್
No,
ಮಾಡಿದ್ರೆ
this,
ಟ್ರಯಲ್ ಕೋರ್ಟ್
this is a total bogus case, my lord.
ಬೋಗಸ್ ಕೇಸ್
6,80,000 is the.
ಬೋಗಸ್ ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಲಿಲ್ವಾ ಎರಡು ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಇಲ್ಲ, ಅದು correct. That is why I am before this honorable court. 6,80,000, she says, he has given me a check. After that, there is a panchayat.
What is your defense counsel?
My defense is she doesn't have the capacity to pay. She says, my husband got the retirement money, from that I have paid. But retirement benefit ಏನಿದೆ, ಎಷ್ಟು ಬಂದಿದೆ, lower court ಮುಂದೆ produce ಮಾಡಿಲ್ಲ. In spite of my application, she has not produced.
The counsel in support of his argument on IA 1/21 content that the complainant was not having source to advance the amount. ಅದ್ ಬಿಟ್ರೆ ಮತ್ತೆ ಇನ್ನೇನ್ ಗ್ರೌಂಡ್?
She has not produced the document
The evidence
to show that she got the retirement benefit.
TW1 and also document exhibit D1 to D4 are marked and the same are not considered by both the courts. In view of the submission as well as leading up defense evidence before the trial court, this court has to examine whether probable case is made out or not, and whether order suffers from its legality and correctness, and hence suspended sentence subject to depositing of 50% of the amount within 4 weeks, and if the same is not
No,
not complied, orders automatically stands vacated.
No, my
Next.
humble submission, my lord.
Trial court is directed to ಅದ್ರಲ್ಲಿ madam inclusive of the amount which was deposited ಅದು ಹಾಕೋಬಿಡಿ. Directed to execute a bond for rupees ಎಷ್ಟು ಲಕ್ಷ ಇದೆ ಇದು? 5,40,000.
2 lakhs, same date, my lord. 4 lakhs.
ಫೈನ್ ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ ರೀ? 5,44,000.
lakh.
ಹೌದಾ? Directed to execute a bond for rupees 2 lakh with one surety before the trial court within 4 weeks.
One submission, my lord.
Issue notice against the respondent.
The 50% may be reduced.
Girish H. Hegde.
No, my humble submission, 50% may be reduced. Why I'll request, my request is, he's bedridden. He cannot arrange that money, my lord.
Next,
19.
19.
Rakshit R.
Rakshit R. Lingaraju. Delay of 237 days. Issue notice. Idar other side idara?
ನೋಟಿಸ್ ಆಗಿದೆ ಮೆಲೋಡ್ಸ್ ರಿಮೈನಿಂಗ್ ಫೈನ್ ಅಮೌಂಟ್ ಬಂದ್ಬಿಟ್ಟು 32,375 ಇದೆ ಮೆಲೋಡ್ಸ್ ಐ ಆಮ್ ಫೈಲಿಂಗ್ ಅ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ದ ಡಿಡಿ ಮೆಲೋಡ್ಸ್
4,25,000 ಆರ್ಡರ್ ಆಗಿದೆ.
4,25,000 ಆರ್ಡರ್ ಆಗಿತ್ತು ಮೆಲೋಡ್ಸ್
ಹಾ.
ಅದಾದ್ಮೇಲೆ 3,50,000 ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಆನ್ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ದ ರೆಸಿಪ್ಟ್ಸ್ ಮೆಲೋಡ್ಸ್
ಹಾ.
ಅದಾದ್ಮೇಲೆ ಲಾಸ್ಟ್ ಟೈಮ್
ಈಗ ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ನೀವು ಡಿಡಿ ಮೂಲಕ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಎಸ್ ಮೆಲೋಡ್ಸ್
ಬೇರೆ ಏನಿದೆ ನೀವು ಕೊಟ್ಟಿರೋ ದುಡ್ಡು? ಅದಕ್ಕೇನಿದೆ ದಾಖಲೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಮೆಲೋಡ್ಸ್ ಇದು ರೆಸಿಪ್ಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಎಲ್ಲ ಆನ್ ದ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ದ ರೆಸಿಪ್ಟ್ಸ್ ಮೆಲೋಡ್ಸ್
ಈ ಕಾಪೀಸ್ ಎಲ್ಲ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೀರಾ? ಈ ರೆಸಿಟ್ಸ್ ಕಾಪಿ ಎಲ್ಲ
ಇಲ್ಲ ಮೆಲೋಡ್ಸ್ ಅವ್ರ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್
ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು ಕಾಪೀಸ್ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ. ತೊಳಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪಿಟಿಷನ್ ವುಡ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಆಲ್ರೆಡಿ ಪೇಡ್ ದಿ ಅಮೌಂಟ್ ಆಫ್ ರುಪೀಸ್ ಎಷ್ಟು?
3,50,000 ಮೆಲೋಡ್ಸ್
3,50,000.
50,000 to the respondent.
ಬಟ್ ಇಲ್ಲಿ ಟೋಟಲ್ ಅಮೌಂಟ್ 4,20,000 ಇದೆ.
Yes, ಮೆಲೋಡ್ಸ್ ಆಮೇಲೆ ಫಸ್ಟ್ ಅಪಿಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಸ್ಪೆನ್ಷನ್ ಆದಾಗ
ಆವಾಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ?
42,625 ಪೇ ಮಾಡಿದ್ದಾರೆ.
ಎಷ್ಟು ಮಾಡಿದಿರಿ?
42,625.
Also council submits that
625 ಮೆಲೋಡ್ಸ್
42,625 was deposited in terms of the order passed by the appellate court. And balance amount is only rupees 32,375. And the same is also paid by way of DD, and DD is also produced along with this memo. The same is taken on record. The counsel for the respondent is absent, and hence an opportunity is given to the respondent counsel to make submission with regard to the entire payment and list this matter on the opening day now date code 28/5.
20. S.S. Sudhindra.
336 days.
Yes.
Other side ಇನ್ನು notice ಆಗಿಲ್ಲ.
ಇಲ್ಲ sir, first time it is coming.
Issue notice on IA 1/23 and IA 2/23 and also on main revision petition against the respondent. List after summarization.
Obliged.
1. C. Rajendra Reddy.
Conditional section 392 and sentenced to undergo for 2 years, my lord. Yes, the complainant punch witness have not supported the case of prosecution.
ಏನ್ offenses ಏನು?
392, my lord.
392.
Yes,
Fine amount deposit ಮಾಡಿದಿರಾ?
yes, my lord.
ಏನ್ ground ಏನ್ ನಿಮ್ revision ಅಲ್ಲಿ?
My lord, complainant punch witnesses have not supported.
Complainant and
Punch witness for seizure of the seizure.
HCGP is directed to take notice. The counsel for the revision petitioner would submit that complainant as well as punch witnesses have not supported the case of the prosecution, and in spite of the trial court convicted the petitioner for the offence punishment section 392 of
Also
IPC.
involved in 11 cases.
And the same is also confirmed by the appellate court. And in view of the submission as well as the grounds urged in the revision petition, sentence is suspended subject to depositing of fine amount. Fine amount ಎಷ್ಟು ಹಾಕಿದ್ದಾರೆ?
2,000.
Huh?
2,000.
2,000. If already deposited before the trial court, no need to deposit the same. The petitioner is directed to execute a bond for rupees 1 lakh with one surety before the trial court within 4 weeks. Allo madam, 4 weeks. Fine amount deposit agilla andre deposit within 4 weeks.
Please.
Call for records. Mahesh Kiran Shetty,
For the petitioner,
8 days,
there is a 8 days delay, my lord.
delay of 8 days is condoned for the reasons stated in the accompanying application. Suspension of sentence annulled.
The trial court, we have already,
Hmm?
we have fully cross-examined the PW1, my lords, and we have arrived as a DW1.
So we contended that we have denied the
What is
relation.
your defense?
My lords may kindly see the page number 34 of my
34.
34.
Yena 34 ಅಲ್ಲಿ.
So in that, my lord, page number para 16, my lord,
Ah.
16 of the judgment,
Ah.
we have denied the relationship of the complaint, my lord,
Hmm.
and the agreement of exhibit P7 dated so and so.
Hmm.
But contend that we had kept in force.
Discloses that there was an agreement between the complainant, her husband regarding loan transaction of rupees 7 lakh.
So our contention is, my lord,
Srinivasa
they have
Swamy.
misused our signed checks, my lord.
Note. Heard the petitioner counsel on IA number 2 of 24 and counsel would submit that check has been misused. And there was no any relationship between the complainant and the petitioner.
Petitioner.
And having considered the submission as well as the accused has been examined as DW1 before the trial court. And matter requires reconsideration. And then sentence is suspended subject to depositing of 50% of the amount inclusive of any amount is deposited before the trial court.
20% already has deposited, my lord.
And if the amount is not deposited within 4 weeks, the order passed by this court sentencing the suspend stands automatically vacated. The petitioner is directed to execute a bond for rupees. This is the amount 3,50,000.
3,50,000.
1 lakh with one surety before the trial court.
Much obliged.
Days of 42 days delay, your lords. Not well, he was not well.
IA 1 of 24 is kept open. IA 2 ಹೇಳಿ.
A to get the check is itself is in dispute, your lords. We are carrying on a check, the entire check transaction was in dispute there in the code below.
Have you led any defense evidence?
We have not, that's, that opportunity was not accorded
ಕ್ರಾಸ್
there.
ಮಾಡಿದೀರಾ PW1 ನ?
Cross ಮಾಡಿದೀನಿ, PW ಕ್ರಾಸ್ ಮಾಡಿದೀನಿ, ಅದರಲ್ಲಿ ಒಂದು opportunity ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ನನಗೆ.
Opportunity ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ?
ಅದು ನಮ್ಮ, this I can't say, ಅದು
Opportunity ಕೊಡ್ಲಿಲ್ವಾ ಅಥವಾ opportunity utilize ಮಾಡ್ಲಿಲ್ವಾ?
ಯುಟಿಲೈಸ್ ಮಾಡ್ಲಿಲ್ಲ.
ಅದೇ ಹೇಳಿ. ನೋಡಿ. Heard the petitioner counsel.
4,51,000, your lords.
ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನು?
Some defense, which check was not given for the cheat transactions at all. It was given.
Counsel would contend that the check was not given in respect of the cheat transaction.
The cheat,
And also counsel contend that no opportunity is given to lead defense evidence to probabilize the case. And in of the submission as well as the grounds urging the revision petition directed to, as a sentence is suspended subject to depositing of 50% of the amount, same madam, in order deducting the amount. Stands vacated, adela same, issue notice against the respondent on IA 1 of 24 and also on revision petition. Yen madam, doubt? IA ಮೇಲೆ ಹೋಗ್ಬೇಕು, ಅದ್ರ ಮೇಲೆ ಹೋಗ್ಬೇಕು. ಬಾಂಡ್ ಹೇಳಿಲ್ಲ, ಬಾಂಡ್ rupees 2 lakh with one surety.
24 Narasimha Prasad ST.
Petitioner prisoner. Proceeding under section 138. He has been convicted to, check amount is 7,50,000. He has been convicted to pay 7,53,000. There was an agreement between the petitioner and the respondent in respect of sale of the property. Subsequently, that agreement came to be cancelled and the check in question was issued. That is the case put forth by the complainant. However, that agreement itself was not been produced. My case is that the check was not issued. The reason why he has been convicted is that he has admitted the check. So therefore, he has been convicted. No other reasons are forthcoming in the judgment.
Why you have not let the evidence before the trial court?
He was, unfortunately, he was convicted in a other case and he was in jail. And as such, he could not adduce his.
ಏನ್ ಯಾವ ಕೇಸಲ್ಲಿ ಅವ್ನು ಜೈಲಲ್ಲಿ ಇದ್ದ?
ಅದು ಯಾವುದೋ ಇದು 324.
324 ಎಷ್ಟು ದಿವಸ ಇರ್ತಾನೆ ಈ ಕಾಲದಲ್ಲಿ ಜಡ್ಜ್?
ಇಲ್ಲ, ಡ್ಯೂರಿಂಗ್ ದಟ್
324 ಗೆಲ್ಲ ಯಾರು ಜೈಲಲ್ಲಿ ಇರ್ತಾರೆ?
ಡ್ಯೂರಿಂಗ್ ದಟ್ ರೆಲೆವೆಂಟ್ ಪೀರಿಯಡ್ he was in jail.
ಬೇರೆ ಹೇಳಿ, ಬೇರೆ ಅಫೆನ್ಸ್ ಯಾವ್ದೋ ಇರ್ಬೇಕು, ಸೀರಿಯಸ್ ಅಫೆನ್ಸ್.
During that relevant period, that's what I was told, my lord. I'm not
324 ಗೆಲ್ಲ ಯಾರು ಜೈಲಲ್ಲಿ ಇರ್ತಾರೆ ಈಗ? 302 ನಲ್ಲೇ ಜೈಲಲ್ಲಿ ಇರಲ್ಲ, ಇನ್ 324
324 ಅಂತ ಹೇಳಿದ್ರು ನನಗೆ. I'm not sure about it.
The counsel appearing for the petitioner would submit that there was no any such agreement or cancellation and a check was misused. And though not led any defense evidence, but PW1 was cross-examined.
Yes, sir. Yes, sir.
PW1 was cross-examined. And probabilized this case, and in spite of it, trial court as well as the first appellate court convicted and confirmed. And in view of the submission as well as the grounds urged in the revision petition, sentence is subjected to suspended subject to depositing of 50% of the amount inclusive of amount which is already deposited before the trial court. And if the same is not deposited within 4 weeks, automatically the order is vacated. Directed to execute a bond for rupees 2 lakh with 2 sureties before the trial court.
Please.
Within 4 weeks.
Great.
Issue notice against the respondent.
Great.
25. B.S. Basavaraju.
The petitioner in this case, my lords. Petitioner is before this court, my lords. My application for 239 was been allowed by the trial court, my lords. Again, the state prefer a revision petition. Same has been reversed, my lords. Facts of the case is, my lords, the CW4 is a witness in the civil case. He was a CW4 in the criminal case, my lords. First, a husband of the complainant files a complaint before the Napaklu police station and the same reasons. The police not registered the complaint, NCR has been issued. Very next day, the complainant files a separate complaint before the women police station.
SCCP is directed to take notice and get the instructions and list this matter immediately after
Meantime, stay.
summer vacation. ಏನಾಗೋದಿಲ್ಲ, ಒಂದ್ ತಿಂಗಳಲ್ಲಿ ಬರ್ಲಿ ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ, ನೆಕ್ಸ್ಟ್ ಡಿಸೈಡ್ ಮಾಡೋಣ.
ಆಯ್ತು.
26.
Notice. Sorry.
SCCP ಆಲ್ರೆಡಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ ಅವ್ರಿಗೆ.
Notice. R2 is
R2 ಇದಾರ?
complainant.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್
R1 is complainant, R2 is SCGP.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್ R1.
26.
ಕರೆಕ್ಷನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನ್ರಿ ಇದು? ಏನ್ರಿ ಇದು ಕರೆಕ್ಷನ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ?
Filed by the respondent number 9 and 10 man.
ಏನಾಗಿದೆ?
Initial ಅನ್ನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಇನಿಷಿಯಲ್ ನೀವ್ಯಾರು ಕಂಪೇರ್ ಆಗೋದು?
ನಾ ಅಪ್ಲೆಂಟ್
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿರೋದ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿರ್ತೀನಿ.
ಏನ್ ನೋಡ್ರಿ ಮೇಡಮ್, ಅಲ್ಲ ಅಲ್ಲ ಆಫೀಸಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೋಬೋದಿತ್ತಲ್ಲ ಇನಿಷಿಯಲ್ನ, ಅದಕ್ಕೆ ಯಾಕೆ ಐ ಹಾಕ್ಬೇಕಿತ್ತು? ಕೊಡಿ ಐಯನ್ ಕೊಡಿ, ಇನಿಷಿಯಲ್ ಮೇಲೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇನ?
ಹೌದು ಸರ್. ಪ್ಯಾರಾಗ್ರಾಫ್ 3 ಆಫ್ ದಿ
9A to C. ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರ? ನೀವೇನ ಅದರ್ ಸೈಡ್?
ಇಲ್ಲ ಸರ್, ನನಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರೆ.
ನೀವ್ ಮಾಡಿದಾರ?
ನನಗೆ ಮಾಡಿದ್ರು.
ನೀವು ಅಪಲೆಂಟ್ ಈಗ?
ನಾವು ಅಪ್ಲೆಂಟ್.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿರೋದು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕಿರೋದು.
ಕಾಪಿ ರಿಸೀವ್ಡ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಅಂತ ಆಗಿದೆ.
ಹೌದು.
ಏನು ಕರೆಕ್ಷನ್ಸ್ ಏನ್ ಮೇನ್ ಇನಿಷಿಯಲ್ ಕರೆಕ್ಷನ್? 9A to AC, respondent encouraged that this court be pleased to amend the typographic error caused in the judgment pertaining to the name of the deceased claimant. Respond number 9. And respond number 10. S. Basappa in place of R. Basappa. Initial matra hangagi.
Initial matra change.
At paras 5, 7 and 8 in the judgment. And pass such other order as. Ashena?
ಅಷ್ಟೇ ಸರ್.
Totally. Heard the counsel for appellant and counsel for respondent who filed an application is absent and taking into note of correction is only mentioning of the initial instead of R, it is mentioned as S. Correct? In paragraph number 5, 7 and 8. And it is only a typographical error and hence His office is directed to correct the same mentioning the correct initial as R instead of S, note kodi ಏನು. And accordingly, IA is disposed of.
27.
Please, your
Sunita H. Singh.
I appear for petitioner, please, your lordship. Lordship, there is.
ಏನು RP ನ ಇದು?
Yes, please, your lordship. There is a delay of 112 days, please, your lordship.
ಕಾಪಿ ಶುರು ಮಾಡಿ ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರ?
ಇನ್ನು ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಈಗ ಅದನ್ನೇ ಕಾಪಿ ಶುರು ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಿ. Instead of no,
Lordship may be pleased to
instead
order.
of issuing notice, I will permit you to serve the copy of IA as well as
Grateful, your lordship.
told. Counsel for the petitioner is directed to serve the copy of IA 1/24 and also the review petition. And the counsel who appears for,
ಅವ್ರು ಯಾರು ಇದ್ರಲ್ಲಿ RS ಅಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಯಾರು appear ಆಗಿಲ್ವಾ?
No, please, your lordship.
Then expert ಏನಾ?
The notice was not ordered at the stage of admission itself, your lordship was pleased to.
RSA admission stage.
ಹೌದು ಸ್ವಾಮಿ.
ಯಾಕೆ ಅದ್ರಲ್ಲೇನಿದೆ ಮತ್ತೀಗ?
No,
What is the error?
there is a point of consideration, a question for consideration which has to be taken into consideration.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದಲ್ವಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಏನ್ ಹೇಳಿ, what is the
Now,
Road.
if your lordships may have to.
admittedly the appellant has purchased the property when the suit was pending.
Your lordship had a.
So when there was an order of injunction.
No, may I
Not to
request your
alienate
lordship,
the
may I
property
request
to
your lordship to
anyone.
kindly peruse page number
ನಿಮಿಷ
20.
ಇರ್ರಿ, ಓದೋಣ, ಏನ್
I'm
reasoning
sorry,
ಇದೆ
I thought your lordship is
ಹಾ.
like.
Order of injunction not to alienate the property to anyone. And also there was no any sale agreement between the appellant defendant number 3 and defendant number 1. And directly the appellant had purchased the property by sale deed dated 16/2/2012. Hence, the very contention of the learned counsel for the appellant that he is the bona fide purchaser cannot be accepted. Therefore, I do not find any ground to admit and frame any substantive question of law. And if any fraud is played by defendant number 1 in favor of appellant defendant number 3, as contended, he has to take action against him in accordance with law. Hence, it is not a fit case to invoke 100 of CPC to admit the appeal and frame substantive question of law. What is the error in the order?
Now, may I request your lordships to kindly peruse page number 20 to 23, your lordships, in my RP, please. There is an agreement of sale that has been entered into between the petitioner and that of the respondents, please, your lordship. And this agreement of sale is much before they filing a suit for specific performance is my specific contention, please, your lordship. And that particular point, your lordship, my colleague was unable to convince before your lordships and put it forth. And thereby, your lordship.
Madam, now producing of this document, this court cannot
No, but that document was. very
review the
much-
order
No, your.
by producing of additional document before the court.
I'm not producing the
If
additional
this is the
document.
document is the part of the record earlier,
Yes, please, your lordship, I had produced it before. the
RSA ನಲ್ಲಿ ಇದೆಯಾ?
RSA ನಲ್ಲಿ I had made a mention that there is an agreement of sale entered into between.
RSA ನಲ್ಲಿ ಇದೆಯಾ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಕೇಳ್ದೆ ನೀವು ಹಾಕಿದಾಗ.
If your lordship.
If this document is not the part of the record in RSA, how can this court can
I
consider
had
this
produced that
document?
document in the RSA, but was not marked because it was only a copy.
RSA ನಲ್ಲಿ ಹಾಕಿದಿರೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, RSA ನಲ್ಲಿ
ಮತ್ತೆ?
ಹಾಕಿರ್ಲಿಲ್ಲ, but this honorable court came to the conclusion that there was no agreement of sale entered into between the petitioner and the owners. But then if your lordships may have to kindly appreciate, this is a
Whether this
document.
whether this agreement was produced before the trial court,
No, please, your lordship.
then
But then your lordship, I am a bona fide purchaser. I have agreement of
maybe
sale in
bona
my
fide
favor.
purchaser,
No,
madam.
Your lordship, 1 minute, please, your lordship. I am a bona fide purchaser. There is an agreement of sale. I am in possession. I have invested. I have put up construction.
Whether you are a party in the trial court?
Yes, please. They have subsequently implemented to me in the year 2017, please, your
Then
lordship.
you would have produced this document before the trial court.
But that document was not entertained by the trial court for the reason that it was only a copy of the document and it was not duly stamped. For some reason, your lordship, this particular document was not. Now,
Yes,
your
madam,
lordship.
RSA ನಲ್ಲಿ ಏನ್ ನೋಡ್ಬೇಕ್ರಿ?
ಅಲ್ಲ ಸ್ವಾಮಿ, I fully. but
ನಿಮ್ಮ
please,
ಪ್ರಕಾರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಈ ಅಗ್ರಿಮೆಂಟ್ ಇಲ್ಲ, ಹಾಕಿಲ್ಲ,
agreement ಬಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ
ಮಾರ್ಕ್
ಸ್ವಾಮಿ.
ಮಾಡಿಲ್ಲ.
ಮಾರ್ಕ್ ಆಗಿಲ್ಲ, ಪ್ರೊಡ್ಯೂಸ್
ಮತ್ತೆ ಮಾರ್ಕ್
ಮಾಡಿದ್ದೀನಿ.
ಆಗದಿಲ್ಲ ನಾನು ಕೋರ್ಟ್ ನ ಪ್ರಿಸ್ಯೂಮ್ ಮಾಡ್ಕೊಳಕ್.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ, ಅದನ್ನ ಮಾರ್ಕ್ ಆಗಿರ್ಲಿಲ್ಲ.
Madam.
ಯಾವ್ದೋ ಕಾರಣಕ್ಕಾಗಿ ಮಾರ್ಕ್ ಆದ್. ನಾವು ಇಫ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಕೈಂಡ್ಲಿ ಆರ್ಡರ್ ನೋಟಿಸ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್ ಬಿಕಾಸ್ ನಾನು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ.
ಆರ್ಡರ್ ನೋಟಿಸ್.
ನಾನು ಪೊಸಿಷನ್ ಅಲ್ಲೂ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ಅಂಡ್ ಐ ಹ್ಯಾವ್ ಪುಟ್ ಅಪ್
Possession ಅಲ್ಲಿ
ಕನ್ಸ್ಟ್ರಕ್ಷನ್
ಇದೆ,
ಆರ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಂಡ್ ಇಫ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್ ಅಲ್ಲ
Left to
ಸ್ವಾಮಿ.
them, told. Heard the review petitioner. Council would contend that there is
ಅಲ್ಲ
an
may
agreement.
I request your lordships to kindly order for issue notice for the simple
No,
reason,
madam,
your lordship.
why court has to issue notice? This court felt that no need to consider and invoke section 100 of CPC.
But now,
And dismissed at the time of admission itself.
but for the, if your lordships may kindly appreciate the material on record, please, your lordship.
Material on record is not there before the trial court as well as the appellate court and also before the second appeal.
ಅಲ್ಲ ಸ್ವಾಮಿ,
How can the court can consider this and review the order?
sale deed ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ, and this fact was not at all brought to my notice. This honorable court before this honorable bench itself has passed the order wherein the bona fide purchaser would have every right to participate in the proceedings and to put forth their defense. But when such being the condition, please your lordship, now
Madam, you are a party to the trial court. You have not placed this document before the trial court and also not filed in the appellate court, and also not filed in second appeal also. What is there to decide on this document in RSA?
lordship, the sale deed was there. I was in possession, and this point of agreement of sale not having been entered into was
That
not
is
at all
with
raised
regard to
up
the
at any
bona
point
fide
of time.
purchaser is concerned.
That was not taken up, your lordship. One opportunity, ma'am, please, your lordship, the
So-
parties have paid court fee
This-
to both
this-
the extent, please, your lordship.
Maybe.
And not
This
only that, your
payment of
lordship,
court fees
Ali,
cannot be a ground.
your lordship, this is 1.5, 2 acres of land wherein they have paid the full sale consideration and made developments on the land also, please, your lordship. And this is the agreement which the plaintiffs are relying upon is only a unregistered blank kind of an agreement, your lordship, which is also taken into dispute by both the owners as well as the bona fide purchaser. That being the reason I'm requesting before your lordships to kindly at least issue notice so that the parties may come before your lordships and also to take up their contention. Agreement of sale ilve irliಲ್ಲ ಸ್ವಾಮಿ ಅವರಿಗೆ, subsequent ಆಗಿ ಮಾಡಿರೋದು. Owners themselves are not admitting that agreement of sale. And mind agreement of sale being prior to the filing of the suit for specific performance, your lordship, and being in the possession and also developments have been taken up on the possession, please, your lordship, may kindly consider that point and see that there is a point to consider.
Yes. Hold. Heard the review petition of counsel. And counsel in the review petition produced a document of sale agreement. Dated
7/7/2011, please, your lordship.
7/7.
2011.
ಎಷ್ಟಿದೆ document? ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಟ್ರ ಏನಾಯ್ತು ಕೊಡಿ. ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಅದ್ರಲ್ಲೇ ಹಾಕಿದ್ದೀನಿ, ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ.
Page number 20.
Annexure B, please, your lordship.
Dated 7/7/2011. And seeks for an order to review the order of this court dated 5th day of September 2023. This court, when the matter was listed for admission, considered the grounds urged in the second appeal. And taking into note of admittedly, the appellant has purchased the property when the suit was pending. And also when there was an order of injunction not to alienate the property to anyone. And also there was no any sale agreement between the appellant defendant number 3 and defendant number 1. And directly, the appellant had purchased the property with sale deed dated 16/2/2012. Hence, the very contention of the learned counsel for the appellant that he is the bona fide possessor cannot be accepted. Now the counsel come up with this document to review the order. And scope of review
May I
is
make
very
one
limited.
small mention, please? I'm
ನಿಮಿಷ
sorry.
ಕೇಳಿದೀನಿ madam. Allow me to
One minute.
dictate the order.
Alla ಸ್ವಾಮಿ,
That's all.
I purchased.
Scope of review is concerned if any material is not considered while passing an order, then court can review the order. And admittedly, this document is not part of the record of the trial court, appellate court, as well as the second appeal. And when such being the case, if the order is apparently without considering the said document, then can review the order. But when the document is not the part of the document, question of entertaining the second appeal doesn't arise. And hence, the same not invoke the review jurisdiction of this court, and hence, based on that document which is produced now, cannot review the order. And hence, no grounds to review the
Your
order
lordship,
passed by this court, and hence the review petition is dismissed.
one point, if your lordship permits me, please, your lordship. ನಾನು purchase ಮಾಡಿದಾಗ suit ಅಲ್ಲಿ I was not a party at all. I didn't know about the injunction order also, your lordship. They have subsequently implicated me in this suit. The question of injunction operating against me and that having been entered in the sub-register is not at all within my knowledge. I have subsequently purchased, before being a party to the proceeding, I have purchased the property, please, your lordship.
The review petition is dismissed with cost of rupees 5,000.
I'm sorry, your lordships may kindly withdraw the pleas. I humbly pray, because first of all, he has been burdened with all the
I've
costs.
already passed an order, that's all.
Obliged.
ನೀವು ಹೇಳಿದ್ದು ಕೇಳಲ್ಲ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ ಹೇಳಿ, ನಾನು ಆವಾಗ್ಲಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ. Even in spite of it, you are not able to hear the court also.
I'm sorry, your lordships.
Yes.
Your lordship may kindly please withdraw the cost, please, your lordship.
No, already passed an order on merits and also dismissed with cost, that's all.
For the appellant, on the last occasion, Lord, your lordship had directed for issue of notice on IA number 1 of 22. To the proposed, 1 of 22 to the proposed respondent.
But the respondent number 1, he had taken hand summons to respondent number 2. He has refused, my lords. I filed a memo along with the affidavit of respondent number 1E on 15/4/24. Respondent number 2 has refused the hand summons.
Hand summons he has refused.
He had refused, my
Court
lords.
notice ಹೋಯ್ತಾ? ಅಂದ್ರೆ ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗ
Yes, my lord.
ಕೋರ್ಟ್ ನೋಟಿಸ್ ಏನಾಯ್ತು?
Court notice ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಆಗಿಲ್ವಾ? Only permission was given to serve the copy.
Copy.
Including ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಯಾರು?
Respondent number 1E. 1E to F.
ಹೋಗಿದೆ ಏನಾಗಿದೆ? ಏನಂತ? Not accepted. Insufficient address ಅಂತಲ್ಲ?
ಅದೇ ಅಡ್ರೆಸ್ ಓದ್ವಿ ನಾವು. ಅದೇ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಇದಾರೆ ನಾವು.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅದೇ ಅಡ್ರೆಸ್ ಇದೆ ಸ್ವಾಮಿ.
ತಗೊಂಡು ಹೋದ್ವಿ, ಫೋನ್ ಮಾಡಿದ್ವಿ, ತಗೊಳ್ಳಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ತಗೊಳ್ಳಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಈಗ ಐಟಮ್ ನಂಬರ್ 13 ಅಲ್ಲಿ is carrying out development, my lords. IA number 1 of 13, I filed not to change the nature of the property.
one of
1 of 2022.
22.
Sorry, IA 1 of 23. In that I have specifically stated in item number 3, they're making
Item
change in the nature of the.
IA
physical
copy
property.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ sir, ಅವನ್ನೇ file ಮಾಡಿ. The old IA 1 of 23.
ನೋಡಿ ಸರ್, acknowledgement ಇದೆ.
I 2 bar 20.
ಅಲ್ಲ ಫಸ್ಟ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಯಾವುದು? ಈ ಅಪ್ಲಿಕೇಶನ್ ಬೇಡ, ಫಸ್ಟ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಯಾವುದು?
Impleading application, Lord, is IA 1 of 22.
1 of 22 ನಾ?
Yes, my lord.
Your lordship has on the last occasion said, in the meanwhile, issue notice of IA 1 of 22.
ಆಯ್ತು.
Then, my lord,
And also, my lord, permitted the respondent, my friend, to take hand summons.
Lord, there are 2 other applications.
ಕೊಡಿ ಆರ್ಡರ್ ಕೊಡಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಕೊಡಿ.
ಒಂದು ನಿಮಿಷ.
ನೀವು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರಾ ರಿಫ್ಯೂಸ್ ಮಾಡಿದ್ಕೆ? ಹಾಕಿದ್ದೀರಾ?
On 15/4/24, I have filed a memo. Yeah, memo along with the affidavit.
ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
ಯಾವಾಗ?
15/4/24.
ತೋರಿಸಿ ನೋಡಿ ಮೇಡಮ್. The appellant is restrained from further alienating the property of item number 12 and 13
13.
in the next state of hearing ಅಂತಿದೆ.
Now, not in item number 13, after, my lords, we told him we have taken the notice. He is making further development in the property, producing the photographs. And in that regard, IA 1 of 23 is pending consideration.
ಇದೆಯಲ್ಲ ಫೋಟೋಸ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
ನೋಡಿ.
May pass the
When
photograph.
this court, having considered matter requires consideration in respect of impleading the proposed purchaser as proposed respond number 2, order to issue notice of IA number 1 of 22 against the proposed respond number 2. And the counsel for the respond number 1C F is also permitted to take hand summons against the proposed respond number 2 in terms of IA number 1 of 22. The counsel for respond number 1C F files memo along with returned hand summons with affidavit stating that he has refused to receive the notice and acknowledge the same and consider the affidavit and also an IA is filed. ಏನ್ ನೀವು ಪ್ರೇಯರ್ ಕೇಳಿರೋದು IA ನಲ್ಲಿ?
Not to
Ah,
make any
IA
change
copy
in
ನಮ್ಗೆ
item
ಬಂದಿದೆ.
13.
IA copy I do not have. One of 23.
ಅಲ್ಲ 14/2/23 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದು ಕೊಡ್ತೀನಿ ಇನ್ನೊಂದು
ಕೊಡಿ.
copy ಕೊಡ್ತೀನಿ.
14
2/23 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದು.
IA number ಯಾವ್ದ್ರಿ?
IA 1/23 my lords.
IA 1/23 for praying the court to restrain. ಯಾರನ್ನ restrain ಕೇಳಿದ್ರಿ ನೀವು?
The proposed respond number 2 from changing
Proposed
the nature
respond
of
number
respond number 2 from changing the nature of item number
in
13.
changing the nature of the property which he had purchased. ಹೌದಾ?
ಹೌದು.
From the appellant.
From the appellant. The notice issued against the proposed respond number 2 also was returned with an endorsement that ಏನಂತ ಬಂದಿದೆ ಮೇಡಮ್ ವಾಪಸ್ಸು? Insufficient address. And counsel submits that the very same address is mentioned in the sale deed also. And when such being the case, when the proposed respondent refused to receive the notice, respondent number 2 is restrained from changing the nature of the property till the next date of hearing. The counsel appearing for the appellant would submit that ಯಾವ್ದು ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರಲ್ಲ?
ಇದ್ರೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಖಡಾಖಂಡಿತವಾಗಿ ಹೇಳ್ತಾರೆ. ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ಇದ್ರೆ ಇನ್ನೊಂದು ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀನಿ.
ಆಯ್ತು.
ಕೊಟ್ಟಿರ್ಬೋದೇನೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನನ್ನ ಹತ್ರ ಇಲ್ಲ.
The counsel is directed to furnish the copy of IA 1/23 to the appellant counsel. Appellant counsel.
Memo ಕೊಟ್ಟಿಲ್ಲ ನೋಡಿ sir. Memo is filed last
Is this
occasion.
matter immediately after summer vacation. Issue note, ಇದು fresh address ಏನ್ ತಗೋತೀರಾ ನೋಡಿ.
ತಗೊಳ್ತೀನಿ.
Issue fresh notice against the proposed respond number 2.
Lordship permission. Dictation starting ಅಲ್ಲಿ IA 1/23 ಅಂತ ಬಂತು, 1/22 ಅಂತ ಬರ್ಬೇಕು.
ಅಲ್ಲ 1/22 for impleading.
ಅದೇ ಆ ಡಿಕ್ಟೇಷನ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ 1/23 ಅಂತ ಬಂತು ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. If I leave it.
22 ನೇ ಹೇಳಿರೋದು.
Second was
Second one 1/23. Wherein he has sought for the order of restraining.
ಫಸ್ಟ್ ಲೈನ್ ಏನೇ 1/20. ಆಯ್ತು.
ಇಲ್ಲ ನೋಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್ ಅಷ್ಟೇ.
ಗ್ರೇಟ್.
ಹ್ಮ್. Twenty-nine, heard in part, criminal RP.
Kumar,
Kumara HCG.
Just now I received the documents, can you pass out? Just now I received the documents.
Sorry, the council HCGP submits that he has received the documents today. Hence list this matter immediately after summer vacation. Interim order granted earlier is extended till next date of hearing.
admission matter 30, Srinivas N.
And for petitioner,
Hmm.
we are going to pay the entire amount in
Hmm?
next month we will clear the amount, check amount.
Dhirendra N Katti.
I appear for the response. But more, today only I filed a collector. Yesterday only I received the invoice of collector. We are make payment. It is relating to the land. So.
ಈ 50% of the amount ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಇದು. ಸೊ ಕ್ಲಿಯರ್ ಮಾಡ್ಬಿಡೋಣ ಅಂತೇಳಿ ವೇಟ್ ಮಾಡ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ. ಅದು ನೆಗೋಷಿಯೇಷನ್ ಆಗ್ತಾ ಇದೆ.
ಕ್ಲಿಯರ್ ಮಾಡೋದಿರ್ಲಿ, ಈ ಆರ್ಡರ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀರಾ?
ಇದು ಆರ್ಡರ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
Sentence is suspended. Accordingly, IA 1/22 is allowed subject to the petitioner depositing 50% of the amount within 4 weeks. From today, deducting the amount already paid. Compliance ಮಾಡಿಲ್ಲ ಇದು?
ಇದು ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಸರ್. ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಸರ್.
ಆಯ್ತು. ತೊಗೊಳ್ಳಿ. The counsel for the appellant would submit that the order dated 18/4/22 is not complied. And submits that going to make the payment of entire amount. And once the petitioner has not complied with the order of depositing of 50% of the amount, and no ground is also made out, and hence the respondent is given liberty to proceed against the petitioner in accordance with law. List this matter.
They said next month they would make the payment. That undertaking also may be taken into.
Now, madam, in terms of the order, they have not complied. 50% ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ.
In our one
Negotiation is
ಕೊಟ್ರೆ
going, that section.
ಪೂರ್ತಿ ಕಟ್ತಾರಾ?
They also know.
I have given liberty, you proceed against him, that's all.
Grateful.
TCR ಏನಾರು ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಬಂದಿಲ್ಲ. ಕಾಲಾಗಿದೆ ಅಷ್ಟೇ.
ಹೌದು ಸರ್.
ಆಯ್ತು. Proceed against. This matter after summer vacation.
Much of.
31, Lakshmi Narayan Shetty.
3,35,000.
IFL ಮಾಡಿದ್ರು.
Apply ಮಾಡಿದ್ದೀರಾ?
ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸರ್, ಎಲ್ಲ
ಹಾ.
ಆರ್ಡರ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ,
ಹಾ.
IO1 ಅಲ್ಲಿ ಆಗಿದೆ, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಆಗಿಲ್ಲ, ಫೈನಲ್ ಹಿಯರಿಂಗ್
ಕಂಪ್ಲೀಟ್ IO1 is allowed and ಇವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು ಸರ್
ರೆಕಾರ್ಡ್ಸ್
ರೆಸ್ಪಾಂಡೆಂಟ್.
ಬಂದಿದೆಯಲ್ಲ? Heard admit list this matter for final hearing. ಕಟ್ಟಿದಾರಂತಲ್ಲ 50%.
ಕಟ್ಟಿದೀವಿ ಸರ್, ಕಟ್ಟಿದೀವಿ, ಅರ್ಧ ರಿಲೀಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
Release
ಇಲ್ಲ, ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ.
ಎಸ್ ರಿಲೀಸ್ ಆಗಿದೆ.
My lords,
Release
they are obstructing in the trial courts, my lord, because the case is pending in the high court, my lord.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರೇನ್ರಿ?
ಹೌದು
ರಿಲೀಸ್ ಗೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ನಾವು ಆರ್ಡರ್ ಮಾಡಿದೀವಾ? ರಿಲೀಸ್ ದಿ ಅಮೌಂಟ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತ
ಆಲ್ರೆಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ರಿಲೀಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ತಗೊಂಡಿದ್ದೀರಂತಲ್ರಿ
ನೋಡಿ
ದುಡ್ಡು?
ಇದೆ.
Instruction ಆಗ್ತದೆ.
50% ಆಫ್ ದಿ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಹಾ.
ನೋಡಿ ಸರ್, ಇದು ಇಲ್ಲೇ ಇದೆ, ಸಾಹೇಬ್ರು ಸೈನ್ ಮಾಡಿ ರಿಲೀಸ್ ಮಾಡಿದ್ದಾರೆ.
ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಂತಲ್ಲ?
obliged.
Heard admit. Post the matter for final hearing immediately after summer vacation.
ಇಂಟೀರಿಯರ್ ಮಾಡಬೇಕು.
ಹಾ?
ಇಂಟೀರಿಯರ್ ಮಾಡಬೇಕು.
ಏನ?
ಇಲ್ಲವರೆಗೂ ಇಂಟೀರಿಯರ್ ಮಾಡಿತ್ತು ಸ್ವಾಮಿ, ಇವತ್ತವರೆಗೂ.
ಎಂಟ್ರಿ ಮಾಡ್ರು ಇವತ್ತವರೆಗೆ ಅಂತ ಇರಲ್ಲ. Sentence is suspended subject to depositing of 50% amount ಅಂತ ಅಷ್ಟೇ. ಮತ್ತೇನ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್
ಲಾಸ್ಟ್
ಮಾಡಿ
ಟೈಮ್ ಹಂಗೆ ಆಗಿರೋದು ಸರ್.
ಇಲ್ಲಿ ಎಸ್ಟೇಟ್ ಅಂತ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಮಾಡಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ.
ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆಂಡ್ ಆದ್ಮೇಲೆ ಅದೇನ್ ಸರ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್?
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಹಂಗಾಗಿರೋದು ಸರ್, ನೆಕ್ಸ್ಟ್ ಡೇಟ್.
ತಗೊಳ್ಳಿ ಎಂಟ್ರಿ ಮಾಡಾರ ಮೆನ್ಷನ್ ಯಾರು ಮೆನ್ಷನ್ suspended for a period of 4 weeks subject to the following conditions. ತಗೊಳ್ಳಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ is extended till next date of hearing.
Great.
Excuse me,
My
Nanjul
lord.
Swami and Radha.
My lord, serial number 29.
Hmm?
Serial number 29, interim order maybe.
29 ಮಾಡಿದ್ನಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದೀನಿ. ನೀವು ಕೇಳಲಿಲ್ಲ, ನಾನೇ ಮಾಡಿದೀನಿ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನೆನಪಿತ್ತು ನನಗೆ. ನಂಜುಂಡ ಸ್ವಾಮಿ ಏನ್ ರಾಧಾ ಹೇಳ್ರಿ. ಏಕೆ
ನಮ್ಮ ಕೊಲಿಗ್ ಫೈಲ್ ಕೂಡ ಕೇಳಿದ್ದೆ, ಇಲ್ಲಿ ಇಟ್ಟಿಲ್ಲ.
ಈ ಸೆಂಟೆನ್ಸ್ ಆಲ್ರೆಡಿ ಸಸ್ಪೆಂಡ್ ಆಗಿದೆಯಾ? ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಿ?
30% ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, 30% ಅಮೌಂಟ್ ವಿತ್ಡ್ರಾಲ್ ಆರ್ಡರ್ ಆಯ್ತು, ತಗೊಂಡಿದ್ದಾರೆ.
ವಿಡ್ರಾಯಲ್ ತಗೊಂಡಿದ್ದೀರಿ?
ತಗೊಂಡೆ.
Heard admit list the matter for final hearing immediately after summer vacation.
33 Guru Prasad ಗೆ
ಗುರು ಪ್ರಸಾದ್ ಎ ಮಂಜುನಾಥ್ ರೆಡ್ಡಿ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್. ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್.
My lord, in this matter,
ಯಾರು ವಾಲಂಟ್ರಿ ಬಂದಿದ್ದಾರೆ? ನೋಟಿಸ್ ನಾಟ್ ಆರ್ಡರ್ಡ್ ಅಂತಿದೆ. ಜಿ ಮಂಜುನಾಥ ರೆಡ್ಡಿ. ಹಾ ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
Lord, in this matter, the contention of the complainant is that he has supplied a chicken, boiler chicken burst to the accused for a sum of rupees 4,349 rupees. Apart from that, he says that 2,50,000 has given as hand load. My lord, after the supply of the material, my lord, we have made the payment of rupees 1,90,000 rupees. And exhibit P10A, my lord, that is produced by the complainant before the trial court. There it shows that he has supplied 3,598 kgs of chicken, my lord.
ಆಯ್ತು.
But in the complaint, he says 4,000 something he has supplied. So his own document contradictory to the supply of the materials, my lord. And he, in the cross examination, he has categorically admitted that he has received the money of rupees 1,90,000. According to me, I have to pay only 1,23,000 rupees is the balance amount. Whatever amount is claiming 6,50,000, it is a check given in the year 2015 when the business started between the complainant and accused, my lord. But it was misused in the year 2018, my lord. So whatever
Heard the petitioner counsel, and counsel would submit that the petitioner is not disputing that he had purchased only 3,598 kgs of chicken. And claim of the complainant is that he had purchased totally 4,800 kgs. But petitioner submits that he has made the payment of rupees 1,90,000. 1 lakh?
90,000, 190.
90,000. And also it is the claim of the complainant that accused had borrowed hand loan of rupees 2,50,000. And the check which was given in respect of the transaction of the year 2015 was misused. And also the petitioner has been examined as DW1, and both the courts have not considered the said probable case of the revision petitioner. Having heard the revision petitioner counsel and also the grounds urged in the revision petition, sentence is suspended subject to depositing of 50% of the amount inclusive of amount which is deposited before the trial court. If any,
25%.
if the same is not complied within 4 weeks, this order stands vacated automatically. The petitioner is directed to execute a bond for rupees. ಎಷ್ಟು ಲಕ್ಷ ಇದೆ ಇದು?
6,50,000.
Bond of rupees 1 lakh with one surety before the trial court. Issue notice already ಬಂದಿದಾರಲ್ಲ counsel.
Notice is not issued in this.
ಆಯ್ತು. ಅವ್ರು ಆಲ್ರೆಡಿ ಇದಾರೆ ತಗೊಳ್ಳಿ. The counsel already filed wakalat without notice and the same is accepted. Call for TCR and the appellate court records. List the matter immediately after summarization.
34, MB Chandrachud.
MB Chandrachud.
138 proceeding.
4,90,000 is the check amount.
4 lakh?
90,000.
That's
denied the execution of the check. Paragraph number 20.
Trial court ordered only for rupees 4,95,000 only.
ನಮಗೆ legal notice service ಆಗಿದೆ. Record page 59 paragraph 20. ಕೆನರಾ ಬ್ಯಾಂಕಿಗೆ ಚೆಕ್ಗೆ ಕೆನರಾ ಬ್ಯಾಂಕಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ. ಕೆನರಾ ಬ್ಯಾಂಕ್ ಚೆಕ್ ಕೆನರಾ ಬ್ಯಾಂಕ್ ಅಡ್ರೆಸ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ.
ಅಕ್ಯೂಸ್ ಇರೋದು ಎಲ್ಲಿ?
ಅಕ್ಯೂಸ್ ಇರೋದು ಬೇರೆ ಕಡೆ.
ಬ್ಯಾಂಕಿಗೆ ಯಾಕೆ ಕೊಡ್ತಾರೆ ನೋಟಿಸ್?
ನೋಟಿಸ್ ಕೊಟ್ಟರೆ ಬ್ಯಾಂಕಿಗೆ. ಕೈಂಡ್ಲಿ ಸಿ ದಿ.
ಅಲ್ಲ ರೀ, ಅಕ್ಯೂಸ್ ಇರೋದು ಎಲ್ಲಿ ಹಿಂದೆ?
ಅಕ್ಯೂಸ್ ಇರೋದು ಕಾಸ್ಟ್ ಏಟ್ ಅಡ್ರೆಸ್.
ವರ್ಕಿಂಗ್ ಇನ್ ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ರೀ.
ಇಲ್ಲ,
ಅದಕ್ಕೆ ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕಿಗೆ ಕೊಟ್ಟಾರ.
ವರ್ಕಿಂಗ್ ಎಸ್ ಎ ಕೂಲಿ. ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್. ನನ್ ಕೆಲಸನೇ ಇಲ್ಲ, ಕೂಲಿ ಕೆಲಸ ಮಾಡೋದು. ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್
ಮತ್ತೆ ವರ್ಕಿಂಗ್ ಇನ್ ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ತುರುವೇಕೆರೆ ಬ್ರಾಂಚ್ ತುರುವೇಕೆರೆ ಟೌನ್ ಅಂತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾನು ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯಿನೇ ಅಲ್ಲ.
ಏನಾರು ಟೆಂಪರರಿ ಏನಾರು ಕೆಲಸ ಮಾಡ್ತಿದ್ರೆ?
ಯಾರು ಇಲ್ಲ. 2ನೇ ಕ್ಲಾಸ್ ಓದಿರೋದು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೆಲಸ ಕೊಡ್ತಾರೆ. ಬ್ಯಾಂಕಿಗೆ ಬಂಡಲ್ಲಿ ಆಸ್ ಇಟ್ ಈಸ್ ಬಂಡ್ ತಗೊಂಡೋಗಿ ಬ್ಯಾಂಕಿಗೆ ಸರ್ವಿಸ್ ಮಾಡ್ಬಿಟ್ಟು ಹೆಲ್ಡ್ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಮಾಡಿ. ನಾನು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೆಲಸದಲ್ಲೇ ಇಲ್ಲ. ಚೆಕ್ ಕೆನರಾ ಬ್ಯಾಂಕ್ ಹೋಗ್ತೀನಿ.
ಕೆನರಾ ಬ್ಯಾಂಕ್?
ಹೌದು, ಕೆನರಾ ಬ್ಯಾಂಕಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
So the counsel appearing for the petitioner would submit that the petitioner is not the employee of corporation bank. And notice is also addressed to the corporation bank. And in the cast title also shown as working in corporation bank, but he never working in the corporation bank. And also no notice was served. ನೀವೇನ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರ? ಹೋಗ್ಲಿ, ನೀವ್ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಕಿತ್ತಲ್ಲ. ನಾನ್ ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೆಲಸನೂ ಮಾಡಿಲ್ಲ ಅಂತ
ಅವ್ರು ಒಪ್ತಾರೆ. ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಒಪ್ಲಿ ರೀ, ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಪ್ರಾಬಬಲ್ ಕೇಸ್ ನೀವ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ. ಮತ್ತೆ ಅಲ್ಲಿ ಹೋಗಿ ಕೇಸ್ ನಡ್ಸಲ್ಲ, ಡಿಫೆನ್ಸ್ ಇಲ್ಲ. ಹೋಗ್ಲಿ, ಅಡ್ಮಿಷನ್ ಇದೆಯಾ?
ಹೌದು, ನನಗೆ
ಅವನು
ಗೊತ್ತಿಲ್ಲ.
ಕಾರ್ಪೊರೇಷನ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿಲ್ಲ ಅಂತ ನೀವು ಕ್ರಾಸ್ ಅಲ್ಲಿ ಮಾಡಿದೀರಾ PW1 ಗೆ?
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಆರೋಪಿ 7ನೇ ಅಧ್ಯಾಯ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಆರೋಪಿ ಕಾರ್ಪೊರೇಟ್ ಬ್ಯಾಂಕಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ.
ಬಟ್ ನೀವು ಚೆಕ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀರಾ?
ಚೆಕ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀನಿ.
ಮಾಡಿಲ್ಲ?
ನನ್ನ ಸಿಗ್ನೇಚರ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀನಿ.
ಮಾಡಿದಿರಿ?
ಹೌದು.
Counsel also would submit that check is also disputed. But he had not led any defense evidence before the trial court. Having considered the grounds urged in the revision petition as well as the submission of the counsel, sentence is suspended subject to depositing of 40% of the amount within 4 weeks. If the same is not complied within 4 weeks, order stands vacated automatically. The Petitioner is directed to execute a bond for rupees 1 lakh with one surety before the trial court within 4 weeks. Issue notice against the respondent.
And delivery.
Hmm?
And delivery.
ಯಾಕೇನ್ ವಾರೆಂಟ್ ತಗೊಂಡಿದಾರ?
ವಾರ ಆದ್ರೂ ಕೊಡಲ್ಲ ನನಗೆ ಕಾಪಿ ಆಫೀಸಲ್ಲಿ.
ಯಾಕೆ ಕೊಡಲ್ಲ?
ವಾರ ಆದ್ಮೇಲೆ ಸಿಗುತ್ತೆ ನನಗೆ ಕಾಪಿ.
ಎಂಟ್ರಿ ಮಾಡ್ರ?
ಡಿಫಿಕಲ್ಟಿ ಐ ಆಮ್ ಫೇಸಿಂಗ್.
ನಾನ್ ಸಂಜೆ ಒಳಗೆ ನಾನು ಸೈನ್ ಮಾಡ್ತೀನಿ, ಯಾಕೆ?
ಆಫೀಸಲ್ಲಿ ಕೊಡಲ್ಲ. ನನಗೆ ಸುಮಾರು ಕೇಸಲ್ಲಿ ಹಿಂಗಾಗಿದೆ.
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಇಶ್ಯೂ ಆ್ಯಂಡ್ ಡೆಲಿವರಿ. ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ಹೆಂಗೆ ಅಂದ್ರೆ ಸಂಜೆ ಒಳಗೆ ಆರ್ಡರ್ ಸೈನ್ ಆಗ್ಬಿಡ್ತವೆ.
ನೀವು ಸೈನ್
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬೆಳಗ್ಗೆ ಸೈನ್ ಆಗಿರ್ತದೆ.
ಅಲ್ಲಿ ಆಫೀಸಲ್ಲಿ ಸ್ಟಾಫ್ ಇಲ್ಲ, ಹೆಡ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಕೊಡಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ.
ಅದು ಸರಿ, 4
ನಾಲ್ಕು ವಾರ ಮುಗಿದೋಗುತ್ತೆ, ಮತ್ತೆ ನಾನು ಎಕ್ಸ್ಟೆನ್ಷನ್.
35 ಕಿಶೋರ್ ಕುಮಾರ್.
138 of
ಹ್ಮ್.
amount 3 lakh.
ಹ್ಮ್?
Amount is 3 lakh.
3 lakhs 392 ಮಾಡಿದ್ದಾರೆ.
392.
ಆಯ್ತು ಹೇಳಿ, ರೀಸನ್ ಏನು? ನಿಮ್ಮ ಡಿಫೆನ್ಸ್ ಏನು?
Second question was issued towards the security and same has been missing.
ಸೆಕ್ಯೂರಿಟಿ
Security.
ಯಾವ್ದಕ್ ಸೆಕ್ಯೂರಿಟಿ ಯಾಕೆ ಕೊಟ್ರಿ?
Then a business security ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೆ you have not disputed the issuance of check and the same is also for security. According to you, you have admitted.
Used the check.
Hmm?
Security purpose ಕೊಟ್ಟರೆ ಅದನ್ನ
Hmm.
misuse ಮಾಡಿದ್ದಾರೆ.
Heard the petitioner counsel and counsel would submit that check is given towards security and the same has been misused. And the petitioner is also examined as DW1 and produced document exhibit D1 to 7. And the same has not been considered in spite of probable cases made out. Having considered the submission as well as the grounds urged in the revision petition, sentence is suspended. Same, madam, 50%. 4 weeks automatically stands vacated if not complied. Execute a bond for rupees 1 lakh with one surety.
37,
Issue notice.
36,
Applying for petition.
Hmm.
My lord, the petitioner filed this petition under section 397 and 401 of CRPC, my lord.
Hmm.
My lord, the petitioner has been convicted of offense punishable under 138 of.
Even defense evidence ಮಾಡಿಲ್ಲ.
Yes, ma'am.
Cross examination ಏನಾರು illicit ಮಾಡ್ಸಿದಿರಾ?
Yes, ma'am. Cross examine ಮಾಡ್ಸಿದ್ದೀವಿ.
ಏನ್ ಮಾಡಿದಿರಿ ಹೇಳಿ?
From cross examination is, my lord, the allegations made out by the complaint is that I have taken a hand loan of 6 lakh rupees from them and I have also not repaid the amount. For that, I have issued a check to the complainant. But my lord, I have not received any amount from the complaint, neither there's any legal debt which has been issued. My lord, the memo which has been issued from the bank endorsement is stating that the signature has been deferred, my lord. I have not even placed my signature on the check. The only reason my check is with their person is.
ಆಯ್ತ್ರಿ, ನೀವ್ ಯಾಕ್ರಿ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ?
I mean, that's
If you denies your signature, why you have not sent the document to the handwriting expert that the signature is not belongs to me ಅಂತ?
No, I have done the cross examination. I have not done my defense.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನ್ ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡಿದೀರಾ ಅಂತ ಕೇಳಿದೆ ಅದಕ್ಕೆ. No need to examine yourself as defense witness, but any answer elicited from the mouth of PW1 regarding your defense is concerned. Nothing.
Lord,
ಎವಿಡೆನ್ಸ್ ಮಾಡಲ್ಲ ನೀವು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನಿಲ್ಲ. ನಥಿಂಗ್ ವರ್ತ್ ಹ್ಯಾಸ್ ಬೀನ್, ಅದೇ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 12 ಅಲ್ಲಿ. During the cross examination of PW1, nothing worth has been elicited in the mouth of complainant in support of the defense.
My lord, I pursue the honorable court to page number 46, my lord. My lord, the only the documents they are marked as the check, the bank endorsement, the legal notice, the bare essentials, my lord. There is.
ಇನ್ನೇನ್ ಮಾರ್ಕ್ ಮಾಡ್ಬೇಕು?
Swami, really bank ಗೆ ನನಗೆ
ಕೊಡಿ, ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೀವು ಸಾಕೊಂಡಿದ್ದೀರಿ, ಪೋಸ್ಟಲ್ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಇದೆ, ಎಕ್ಸಿಬಿಟ್ P5. You have not given any reply. And you have also not led any evidence.
Swami,
Subject to depositing of 50%. Reasons are there, madam. Heard the petitioner counsel and counsel would submit that he has not given any check and the very check is disputed, but the same is not sent to the handwriting expert denying the same. However, taking into note of grounds urged in the revision petition, suspended subject to ಅಷ್ಟೇ, ಬಾಕಿದೆಲ್ಲ ಹಾಕ್ಬಿಡಿ.
much obliged.
ಇಲ್ಲಿ ಏನು ಮಾಡಲ್ಲ, ಇಲ್ಲಿ ಬಂದು ರಿವಿಷನ್ ಅಲ್ಲಿ ನಿಂತ್ಕೋತೀರಾ.
37, ಲತೀಫ್ ಬಿ.
ಇದ್ಯಾಕ್ ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಅಂತ ಇದ್ಯಾಕ್ ಪೋಸ್ಟ್ ಆಗಿದೆ ಮೇಡಮ್? ಲಾಸ್ಟ್ ಟೈಮ್ ಪೋರ್ಟಲ್ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ ಏಕೆ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಅಂತ ಇದೆಯಲ್ಲ, ನಾನು ನೋಡಿದ್ದೀನಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ. Why you have moved? What is the urgency? What is the urgency ರೀ? 392 offense. ಆಯ್ತು. What is the urgency in there? After summer vacation ಅಂತ ಇದೆಯಲ್ರಿ ಅದ್ರಲ್ಲಿ? ಫೈನ್ ಅಮೌಂಟ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀರಾ? ತೊಗೊಳ್ಳಿ. Order the petitioner counsel. The counsel would submit that trial court not considered the ingredients of the offence under section 408, 120B and section 392 of IPC and committed an error in appreciating the evidence. ಅದಕ್ಕಿಂತ ಮುಂಚೆ HCGP is directed to take notice. Notice ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಲ್ಲಿಗೆ? ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿಲ್ವಾ? Having considered the submission of the counsel and also the grounds urged in the revision petition, sentence is suspended subject to payment of fine amount imposed by the trial court if it is not deposited within 4 weeks.
Submission,
ಹೇಳಿ ಏನು?
they have robbed the 6.972 kg gold ornaments. 6.972 kgs from. 6.972 grams kg gold ornaments from Manappuram.
Gold
Palace.
ornaments.
And also cash of rupees 1,60,000 from Manappuram.
ಏನ್ ಚೈನ್ ಸ್ನ್ಯಾಚಿಂಗ್?
Chain snatching ಅಲ್ಲ. Manappuram Finance ಅಲ್ಲಿ gold ನ ಇದ್ ಮಾಡಿದ್ರು.
392 ಅಲ್ಲೇನ್ರಿ?
Rashtrapati Sanabal court already suspended the sentence.
Totally malad
104 ಗೆ ಮಾಡಿದೀವ. ಕೊಡಿ ಹಾಕ್ರಿ ನೋಡು.
15 kg gold ornament. 15 kg gold.
15 kg gold.
ಹೌದು. All the accused, 4 accused.
Working as a watchman in the same gold loan finance ಅಂಗಡಿಲ್ಲ?
ಹೌದು. Okay.
Connected ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಇದೆಯಲ್ರಿ ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆನ್ಷನ್. Directed to deposit 50% of the fine amount deducting the amount already been paid within 4 weeks from today. Execute a bond for rupees 1 lakh with the 2 sureties for the like sum to the satisfaction of the trial court.
Is the accused number 2. Accused is accused number 2.
268 on the 491 of 24.
Case number 1 and 4.
Same order.
Kindly
Suspend ಆಗಿದೆಯಲ್ಲ ಇನ್ನೇನು?
kindly connect with the. Kindly
Friendly?
connect with the.
ತೊಗೊಳ್ಳಿ. ಕೊಡಿ ಮೇಡಮ್. The counsel for the revision petitioner would submit that other criminal petitions number criminal RP number 491 of 24 and 268 of 24 are connected. Since other accused have also filed revision petitions. Revision petition. And hence registry is directed to put up all these revision petitions together for admission. ಅಂತ ಹಾಕೊಳ್ಳಿ. ಆಮೇಲೆ this court already suspended the sentence in respect of other accused persons. Terms conditions ಎಲ್ಲ ಅದನ್ನ ಹಾಕೋಬಿಡಿ ಮೇಡಮ್. Hence sentence is suspended ಅಂತ ಹಾಕೊಡಿ.
38.
ಶಂಕರ್ ಎಂ ನಾಯ್ಕ್.
Appearing for petitioner, my lordship, serial number 38. My lordship, in this case, other than check, no documents has been produced by the complainant and no source of income has been, produced by the complainant, my lordship. Out of 50%, which is ordered by the appellant court, 20% we have deposited in the trial court, my lordship. The parties are about to get settled.
What is your defense? before the trial court.
Before the trial court is that we have taken only 1 lakhs, my lordship. We don't deny that hand loan of 1 lakhs, my lordship.
1 lakh.
1 lakhs.
Check.
We don't deny that, no, out of friendship, they had transactions, my lordship. They had a 10 plus years of friendship, and out of that, he sought 1 lakhs for his mother's expense, medical expenses. So we don't deny that we haven't taken that 1 lakhs rupees from the complainant, but he has, taken check from the accused, which is the petitioner in this case.
The counsel for the petitioner would submit that petitioner has taken only hand loan of rupees 1 lakh
Yes, my lordship.
in order to meet the medical expenses of his mother,
Mother.
and not taken the hand loan of rupees 3 lakhs.
No, my lordship.
As contended by the council. And the PW1 cross madidira,
Illa, my lordship. We have not given sufficient time to cross-examine the PW1.
PW1 cross madilla.
Illa, my lordship.
Cross madilla andre what is there to decide in revision petition, madam?
My lordship, our settlement ಗೆ
No
ನೋಡ್ಕೊಳ್ತಾ
rebuttal
ಇದ್ದಾರೆ.
evidence on behalf of the accused to disprove the case of complainant.
Settlement ಗೆ ನೋಡ್ತಾ ಇದ್ದಾರೆ, my lordship ಅವರು. ನಾವು 2 ಲಕ್ಷ ಕೊಡ್ತೇವೆ, 1
We
ಲಕ್ಷ
heard that
seats.
the accused towards discharge of lawful debt has issued the check. You cross ಮಾಡಿಲ್ಲ, not entered into witness box. No ground, madam. Revision ಅಲ್ಲಿ ಏನಿಲ್ಲ, decide ಮಾಡಂತದ್ದು.
My lordship, for a time being, the
Matter is listed
sentence
for
may be
admission.
suspended, my lordship. Our settlement ಗೆ ನೋಡ್ತಾ
Revision
ಇದ್ದಾರೆ.
petition is filed before this court. And the trial court order in paragraph number
My lordship, for a time being, the sentence may be
9.
suspended.
is very clear that PW1 has not been cross-examined. And also the accused has not entered into a witness box to rebut the statutory presumption drawn in favor of the complainant under section 118A and 139 of any act. And also made an observation that there is no any rebuttal evidence on behalf of the accused to disprove the case of complainant. When the PW1 was not cross-examined and also not led any defense evidence, and nothing is there to decide in the revision petition. And scope of revision is very limited, and this court, while exercising the power under revision, only examine whether the order suffers from its legality and correctness. And nothing is there to decide in the revision petition when the PW1 was not cross-examined and not set any defense before the trial court, and hence I do not find any ground to entertain the revision petition, and hence revision petition is dismissed.
39, Halima Amin.
138 of NA Act.
Hmm.
Check amount is 3,30,000 and the fine amount is 3,35,000. He was on bail during the proceedings in both the courts, my lord. He has
Cross
not.
madidira, madam.
Yes, my lord. That is all done.
Defense evidence madidira.
This evidence madilla, but cross ಅಲ್ಲಿ he himself has admitted that page number 36 may be perused, my lord. He has admitted that the check is not, the case is that, my lord, 50,000 each was deposited by the complainant in the name of his wife, his child and himself. Totally 1,50,000, and then there was no any interest received so far. Then the check was issued 3,30,000. But my lord, the check was presented. The check is after 9 years, 7 years of winding of the finance corporation. He has admitted, page number 36, my lord, from below some 7-8 lines, my lord. He knew that the Nalina Finance Corporation came to be closed in the year 2009, but he denied that payment FD with the interest finance corporation before going to wind up his business. It is suggested that the check which was issued to the other transaction had been misused by the complainant. But another sentence is very important. my
But
lord.
the petitioner counsel.
He admitted.
And counsel would submit that the check was given in respect of other transaction is concerned was misused. And PW1 was effectively cross-examined and
Check was
made
not
out the probable case. Having considered the submission of petitioner counsel and also the grounds urged in the revision petition. Sentence is suspended subject to depositing of 50% of the amount, inclusive of the amount which was deposited before the trial court, if any.
20,000.
And the same has to be deposited within 4 weeks. If the same is not complied with the order, stands automatically vacated. Directed to execute a bond for rupees 1 lakh with 1 surety before the trial court and issue notice against the
Orders,
respondent.
difficult to get the orders, my lord. Even if the lordship signs, it is difficult to get the orders. ಒಂದೊಂದು ತಿಂಗಳು ತಕೊಳ್ತಾರೆ.
ಏನು?
Order ಅಲ್ಲಿ ಕಾಪಿ ಸಿಗ್ಲಿಕ್ಕೆ ಒಂದೊಂದು ತಿಂಗಳಾಗ್ತದೆ ಕೆಳಗೆ.
And delivery ಬೇಕಾ?
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಟ್ಟರು ಆಗುದಿಲ್ಲ, ಒಂದ್ 4 ದಿವಸದಲ್ಲಿ ಕೊಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಸಾಕು.
4 ದಿವಸದಲ್ಲಿ ಕೊಡೋದು ಅಂತೇನಿಲ್ಲ. ನೀವು ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿ ಇವತ್ತೇನೆ ನಾಳೆ ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ ಅಷ್ಟೇ.
ಸಿಗುವುದಿಲ್ಲ ಮಿಲಾಡಿ, ಕಷ್ಟ. ಕೆಳಗಡೆ ಹ್ಯಾಂಡ್ಸ್ ಇಲ್ಲ ಅಂತಾರೆ.
ಹ್ಯಾಂಡ್ಸ್ ಈ ಹೈಕೋರ್ಟ್ಗೆ ಏನು 4,000 ತುಂಬಬೇಕು ಹ್ಯಾಂಡ್ಸ್ ಕೊಡಕ್ಕೆ. ಇದ್ದವ್ರು ಕೆಲಸ ಮಾಡಲ್ಲ.
40.
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ, ಐ ಟೇಕ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ.
ಆಯ್ತು, ಕೊಟ್ರೆ ಮೆಮೊ ಕೊಟ್ರೆ ಮಾಡ್ತೀವಿ.
ಕೊಡ್ತೇನೆ ಈಗಲೇ. ಮೇ ಬಿ ಆರ್ಡರ್ಡ್, ರೈಟ್ ನೌ ಐ ಫರ್ನಿಶ್.
ಮೆಮೊ ಕೊಡಿ ಮೇಡಮ್, ಇಶ್ಯೂ ಅಂತ ಮಾಡ್ತೀವಿ.
40. ಚಂದ್ರನಾಥ್ ಹರಿ.
ಮಾರಿಕ ಹೇಳ್ರಿ.
The petitioner.
ಹಾ.
Check amount is 1,50,000. Both courts have
1,55,000 ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
order ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು.
Both courts have dismissed.
ನಿಮ್ದೇನ್ ಡಿಫೆನ್ಸ್ ಏನು?
My defense is that the legal notice what they have served is not served on me.
ಹಾ.
Issue ಮಾಡ್ರು, wrong address ಗೆ ಕಳ್ಸಿದ್ದಾರೆ ಅಂತ. The other.
ಪೋಸ್ಟಲ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ನೋಡ್ರಿ, ಎಕ್ಸಿಬಿಟ್ P7.
That is the, my lord, but that is not to the address where I reside ಅಂತ ನಾನು.
ಅಡ್ರೆಸ್ ಯಾವ್ದಾರ ಆಗ್ಲಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಾ ಇಲ್ಲ?
Please. Then I would disputed his financial capacity. That is not proved. He has not furnished any other document.
Told. Heard the petitioner, counsel and counsel would submit that legal notice has not been served. And also the complainant was not having any capacity to take the money. And also counsel would submit that he has been examined as DW1 and got marked document exhibit D1 to D5. And the same has not been considered by the trial court. Having considered the submission of the counsel and also the ground searching the revision petition, and sentence is suspended subject to depositing of 50% of the amount inclusive of the amount in deposit made by the petitioner. And if the same is not complied within 4 weeks, order stands automatically vacated. Directed to execute a bond for rupees 50,000 with 1 surety within 4 weeks, issue notice against the respondent.
Please.
41.
Oblige.
Shankar Reddy.
Udra. ಅವಾಗ್ಲೂ ಇರ್ಲಿಲ್ವಾ? ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿರ್ ನೋಡಿ ಬರ್ತಾರೆ.
42. Girish R.
How you can file RP directly to the High Court counsel? Externment order alwa? How you can directly come to an High Court? You can also file a revision before the district and sessions judge.
ಅರ್ಲಿಯರ್ ಇದೇ ಪೆಟಿಷನರ್ ಮೇಲೆ ಸೇಮ್ ಅರ್ಲಿಯರ್ ಇದೇ ಪೆಟಿಷನರ್ ಮೇಲೆ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಆರ್ಡರ್ ಆಗಿತ್ತು.
ಏನಾಗಿದೆ ಆರ್ಡ್ರು? ಲಾರ್ಜರ್ ಬೆಂಚಿಗೆ ರೆಫರ್ ಆಗಿದೆ. ಹೌದಲ್ಲ? ಹಾ? ಲಾರ್ಜರ್ ಬೆಂಚಿಗೆ ರೆಫರ್ ಆಗಿದೇನ್ರಿ? ರೆಫರ್ ಆಗಿರ್ಬೇಕಲ್ಲ ಲಾರ್ಜರ್ ಬೆಂಚಿಗೆ. ಮ್ಯಾಟರ್ ರೆಫರ್ ಆಗಿರ್ಬೇಕು ನೋಡ್ರಿ ಲಾರ್ಜರ್ ಬೆಂಚಿಗೆ. ರಿವಿಷನ್ ಪಿಟಿಷನ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ. You can invoke the very revision jurisdiction before the district court, district and session judge. ಎಲ್ಲದಕ್ಕೂ ಹೈಕೋರ್ಟ್ ಕೋರ್ಟ್ ಬರೋದಲ್ಲ. ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್
ರೆಫರ್ ಆಗಿದೆ. ಮ್ಯಾಟರ್ ರೆಫರ್ ಆಗಿದೆ. ಫಾಸ್ಟ್ ಕ್ವೆಶ್ಚನ್.
WP 392 of 2023.
So ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ.
ಹಾ? ಇದೆಯಾ ಅದು ಆರ್ಡ್ರು?
ಹಾ ಸ್ವಾಮಿ.
ಏನಂತ ಮಾಡಿದಾರೆ? ಯಾವ್ದ್ರಿ ಅದು ರೆಫರ್ ಆಗಿರೋದು ಡಿವಿಷನ್ ಬೆಂಚಿಗೆ?
Kindly pass on.
Actual revision not maintainable before this court. Remedy lies elsewhere, not before the High Court. ಇದರಲ್ಲಿ ಮೇಂಟೈನಬಿಲಿಟಿ ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ.
Also he involved in two cases. He involved in 302 cases. Also he involved in 302 cases.
ಆಯ್ತ್ರಿ 302 ಕೇಸ್ ಒಂದ್ರಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆದ ತಕ್ಷಣ
ಇನ್ನೊಂದ್ ಮ್ಯಾಟ್ರ್ ಇದೆ. ಇನ್ನೊಂದ್ ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಹಾ?
ಎರಡು ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಹಾ?
ಇನ್ನೊಂದ್ ಮ್ಯಾಟ್ರ್ ಇದೆ.
ಇನ್ನೊಂದ್ ಮ್ಯಾಟರ್ ನಾನು ನೋಡಿದೀನಿ. ಅದ್ಯಾವ್ದು ಅಫೆನ್ಸ್ ನೋಡಿ. ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಫೈಲ್. ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಫೈಲ್. ಅದ್ಯಾವ್ದೋ ಒಂದು ಬೇರೆ ಕೇಸು. ಹಾ? ಅಫೆನ್ಸ್ ಏನ್ ನೋಡಿ ಅದು ಇದೆಯಾ?
Offense 115
ಓನ್ಲಿ ಇರೋದೇ ಎರಡು ಕೇಸು. ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಫೆನ್ಸ್ ಏನ್ ನೋಡಿ 115 120B 143 149 511 ಆಫ್ IPC. ಈ ಕೇಸಲ್ಲಿ ಎಕ್ಸ್ಟರ್ನಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕಾಗುತ್ತಾ? ಹಾ? 302 IPC ರೆಡ್ ಬಿ ಸೆಕ್ಷನ್ 34 ಆಫ್ ಸೆಕ್ಷನ್ R&S. ಅದ್ ಬಿಟ್ರೆ ಏನಿದೆ? ಥ್ರೆಟ್ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ? ಥ್ರೆಟ್ ಮಾಡಿದಾನೆ ಅನ್ನೋದಕ್ಕಾರು ಏನಿದೆ? ನೋಡಿ ಹೇಳಿ, ಮಧ್ಯಾಹ್ನ ಹೇಳಿ. ಮೋಸ್ಟ್ಲಿ ರಿವಿಷನ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಂತ ಏನೋ ಒಂದು ಲಾರ್ಜರ್ ಬೆಂಚಿಗೆ ರೆಫರ್ ಆಗಿದೆ. ಮಧ್ಯಾಹ್ನ ಹೇಳಿ. ರಿವಿಷನ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಂತ ಸೇಮ್ ಇಶ್ಯೂ ವಾಸ್ ನಾವೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ವಿ. ಜಸ್ಟಿಸ್ ನರೇಂದ್ರ ಪ್ರಸಾದ್ ಒಂದು ಆರ್ಡರ್ ಜಸ್ಟಿಸ್ ನರೇಂದ್ರ ಪ್ರಸಾದ್ ಅವ್ರದ್ದು ಏನೋ ಆರ್ಡರ್ ಇದೆ ಒಂದು. ಹಾ, ಇವತ್ತೇನು ಕೇಸ್ಗಳೇ ಇರ್ಲಿಲ್ವಾ? ಇಷ್ಟ ಆಗ್ತವ್ರು ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ ಆತ. ಲಾಸ್ಟ್ ಡೇ ಸಾಹೇಬ್ರು ಹೋಗಿ ಇಳ್ದೋಗಿ ಕುತ್ಕೊಳ್ಳಿ ಅಂತಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್
43
petition.
ಯಾರ ಕೋರ್ಟಲ್ ಮೂಡ್ ಇದೆ?
He has already served the default sentence.
Huh?
He already served the default sentence. That he was taken into custody before, as per the order of this honorable court by the trial court. On
they given an undertaking before this honorable court and made a part payment. Then after they become a default. This honorable court given a sufficient time, then after issued the NBW. On the basis of the NBW issued by this honorable court,
Since
Taken
6
into
months he is in custody, madam.
Accused is sentenced to pay a fine of rupees 10 lakh. In default to undergo simple imprisonment of 6 months. 6 months complete ಆಗಿದೆಯಾ?
Also,
ಯಾವಾಗ?
was arrested on 13/10/2023. 13/10/2013 was arrested. Kindly see order dated 14/7/2000.
ಕೊಡ್ರಿ ಮೇಡಮ್. ಏನ್ರಿ ಸೆಂಟೆನ್ಸ್ ಇರೋದು ಓನ್ಲಿ ಡಿಫಾಲ್ಟ್ ಸೆಂಟೆನ್ಸ್.
That's
ಅಲ್ವಾ? ಯು ಆರ್ ನಾಟ್ ಚಾಲೆಂಜ್ ದಿಸ್ ಆರ್ಡರ್. ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ.
ಓನ್ಲಿ ಡಿಫಾಲ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಏನಾದ್ರು ನೀವು ಕ್ವಶನ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ.
ಇಲ್ಲಲ್ಲ. ಅಷ್ಟೇ.
My only that reserve a liberty to recover the fine amount.
ಸ್ಟೋರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಈಗ 6 ತಿಂಗಳು ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ ನೋಡಿದೀರಾ?
Also 21/10/2000.
ಯಾವಾಗ 14/7/23 heard in part. Presence of the petitioner is noted. Undertaking memo and submit that he will abide by the terms and conditions. Are taken a note on as per the said governments, the petitioner is ready to pay the amount of rupees 2 lakh on or before 8/8/23. Hence it is appropriate to adjourn the matter to 8/8/23 for first payment ಅಂತ ಆಯ್ತು.
13/10/2023.
8/8/23. In case petitioner fails to perform, ಏನಾಯ್ತು? This matter on 16/8/23 to pay first installment of rupees 2 lakh. ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ, ಕಸ್ಟಡಿ ತಗೊಂಡಿದ್ದಾರೆ. ಇವರ NBW ಮಾಡೋರು.
13/10/2013 madam. 13/10/2023.
Thirteen
13/10/2023 madam.
He present commissioner of police Bangalore. ಏನಕ್ಕೆ? ಕಸ್ಟಡಿಗೆ ಯಾವಾಗ ತಗೊಂಡಿದ್ದು?
My lord, as per the order dated 13/10/2023, he was taken into custody on 21/10/2023.
13/10.
Also,
Memo of undertaking.
jurisdictional police was directed to arrest him and produce before the trial court and
On production of the accused petitioner before the trial court is directed to ensure the memo filed by the accused has to be complied.
please, madam. As per the my lord, order of this honorable court, on 21/10/2023 was arrested.
21/10/2023. 21/10.
Also. And arrested, he was sent to judicial custody.
21/10 ಅಲ್ಲೇ.
Also.
ಆಮೇಲೆ 10/11 ಅಲ್ಲಿ ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, ಕಸ್ಟಡಿ ತಗೊಂಡಿದ್ದಾರೆ.
Also. ಅದಾದ್ಮೇಲೆ
ಅವಾಗಿಂದ ಕಸ್ಟಡಿ ಇದಾನಲ್ಲ?
Also.
ಅವಾಗಿಂದ ಕಸ್ಟಡಿ.
In fact, I have filed bail application. Last date appearing this honorable court was.
Heard the petitioner counsel and also the counsel appearing for the respondent. And it is not in dispute that petitioner was taken to judicial custody on 21/10/23. And also on perusal of the order impugned. A default sentence has been imposed against the petitioner while convicting him for the offence punishable under section 138 of N Act. Was ordered to pay a fine of rupees 10,05,000. And in default to undergo simple imprisonment for 6 months. And out of that amount of rupees 10 lakh is to be paid to the complainant as compensation. Having considered the judgment passed in CC number 50372 of 2015. And with regard to the sentence, no appeal is filed by the complainant respondent. And only appeal is filed by the revision petitioner in criminal appeal number 1558 of 2018. And the same was dismissed and order of the trial court is confirmed. And when suspending the case, when he has already served the sentence for a period of 6 months, that is also a default sentence. Question of continuing. Him in custody doesn't arise. Hence, ನೀವು ಅಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿಲ್ವಾ 6 ತಿಂಗಳು ಯಾವಾಗ ಲ್ಯಾಪ್ಸ್ ಆಗಿದ್ದು?
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ ಅದು ಇದು?
ಇಲ್ಲ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಕ್ಕೆ
ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ರೀ?
ಆರ್ಡರ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ
ಅಲ್ಲಿ
ಅಪ್ಲಿಕೇಶನ್ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಪ್ರಕಾರ ಅವ್ರು ಒಳಗೋಗಿರೋದು. ದೇರ್ಫೋರ್ ಗೆಟ್ ಆರ್ಡರ್ ಫ್ರಮ್ ದ ಆನರಬಲ್ ಹೈಕೋರ್ಟ್ ಅಂತ.
ಹಾಗಂತ. ಏನಾಯ್ತು ಮೇಡಮ್ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಏನ್ ಹೇಳಿದೆ? Doesn't arise, and hence there is no any merit in continuing these proceedings, and hence this petition become infructuous. However, liberty is given to the complainant to recover the said amount.
ರಿಲೀಸ್ ಆರ್ಡರ್ ಮಾಡಿ.
Huh?
ರಿಲೀಸ್ ಆರ್ಡರ್ ಮಾಡ್ಕೊಂಡು.
The registry is directed to intimate the jail authority to release him since he has already undergone sentence for a period of 6 months.
Much over.
44, 41.
The husband's petition and order of maintenance. The wife is also well qualified, earning before. At the time of filing the application, obviously she has resigned her job without any reasons and sought for maintenance. She is a B graduate, in fact, staying in the house rented premises of belonging to the respondent, a petitioner, sorry. Petitioner's sister. There was an order of maintenance along with alternate accommodation she had sought. E-address she had given, though there was rented person already rented there. The court said alternative arrangement can be made. However, what she did is, with the help of the police, she throws the tenant and occupies forcibly, which report is also there.
Where is the impugned order of
Re-
magistrate?
It is at page 1.
Page 70,
Yes, my lords.
seeking an ad interim ex parte order to
Yes, my
direct the
lords.
respondent number 1
Yes,
to
my lord.
pay
Please,
interim
sir.
maintenance of rupees 2 lakh
Yes.
per month, and filed another A under section 19 of protection of women from provide separate residence to the petitioner. The said applications are also supported the detailed affidavit. What is the order?
Plus order is 25,000.
Respondent is directed to pay an amount of rupees 25,000 per month.
25,000 per month.
Possession of the respondent shall not disturb the petitioner's possession of house stated in the complaint cast title, and the first respondent shall pay the rent of the said premises along with other charges. If the petitioner is not residing in the said premises, the first respondent shall provide separate residence to the petitioner till the disposal of the main petition. Main petition and dispose ಆಗಿದೆಯಾ ಇನ್ನು ಇದೆಯಾ?
Illa, main petition is for domestic. What happened, my lords?
ಅಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Pending ಇದೆ, pending ಇದೆ. They have not even led evidence. ಅವ್ರಿಗೆ ಬರೀ ಕೂತ್ಕೊಂಡು, that is what even the court advised. She being an engineering graduate, she wants to only sit at home, seek for maintenance and then not even go ahead with the matter. He filed the divorce petition. Adadmele she filed this domestic violence, so 498A implicating all the family members.
What is he? Petitioner?
My lords, he's in the job.
What is his
Software job, my lords.
software engineer?
Software engineer.
Ah.
She is also engineer, was working earlier. However, now I am not aware. My lords, your lordship is well aware.
The advocate for the petitioner claimed that rupees 5,14,150 has been credited to the bank account of first respondent.
That is withdrawn also, my lords.
2019. So and so. Whatever the contents of the parties, even according to the payslip furnished by the respondent for the month of December 2020, his gross salary is rupees 2,09,874 per month. Hence, the interim maintenance has to be decided on the basis of his salary. Principal of that petitioner being the wife of first husband is entitled to live life in a manner of first residing living. Deciding all these facts per month awarded interim maintenance. Yes.
That's literally at the time of granting stay, twice 4 lakhs amount that is also withdrawn by her. Number of efforts made by the court to advise her to settle the matter. Illa 498 ella admele police complaint to ella. Now she says, no, I don't want to settle the matter. I want to go live with him only. B graduate. Does not want to earn. Stays in the rented premises, iurdene. She just wants to take 25,000 every month and then prolong the litigation. Idrali, milords, of course, this was, I procured a certified copy. It was a report by Law and Order Police Station itself, how she has forcibly thrown the tenant and occupied. ಅವರೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Right, premises belongs to whom?
For him, husband.
Husband premises.
Yes. There was an order, if that is not vacant, to provide alternative accommodation. But she was hell bent ಅದೇ ಮನೆಗೆ ಸೇರ್ಬೇಕು ಅಂತ ಟೆನೆಂಟ್ ನ ದಬ್ಬಾಳಿಕೆ ಮಾಡಿ ಓಡಿಸಿ she has occupied that premises. And that report is there.
ಅದಕ್ಕೊಂದು ಬೇರೆ ಕೇಸ್ ಆಗಿದೆಯಾ?
Milords?
ಟೆನೆಂಟ್ ನ ಖಾಲಿ ಮಾಡಿಸಿದ್ರು ಅಂತ ಏನಾರ ಒಂದು ಕೇಸ್ ಆಗಿದೆಯಾ ಅಂದೆ?
ಅಲ್ಲ, ರಿಪೋರ್ಟ್ ಇದೆ ಸ್ವಾಮಿ.
ಏನ್ ರಿಪೋರ್ಟ್ ಅದು?
ಬೈ ಪೊಲೀಸ್ ದಿಸ್ ಥಿಂಗ್ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ನಂತರ CDPI ರವರು ತಮ್ಮ ಪರವಾಗಿ ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳಾದ ಶ್ರೀಮತಿ ಶ್ರೀದೇವಿ ಅವರನ್ನು ಸ್ಥಳಕ್ಕೆ ಕಳುಹಿಸಿದ್ದು, ಶ್ರೀದೇವಿ ಅವರು ಮತ್ತು ನಾವುಗಳು ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಸದರಿ ಕಟ್ಟಡದ ನೆಲ ಹಂತಸ್ತು ಮತ್ತು 2ನೇ ಮಹಡಿಯಲ್ಲಿರುವ ಮನೆಯಲ್ಲಿ ಬಾಡಿಗೆದಾರರು ವಾಸವಾಗಿದ್ದು, 1ನೇ ಮಹಡಿಯಲ್ಲಿ ವಿಜಯಲಕ್ಷ್ಮಿ ಹಿರೇಮಠ ಮತ್ತು ಮಗಳು ಹಾಗೂ ಅಳಿಯ ವಾಸವಾಗಿರುವುದು ಕಂಡು ಬಂದಿದೆ. ಈ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ವರದಿ ನೀಡುವುದಾಗಿ ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳಾದ ಶ್ರೀದೇವಿರವರು ಹೋಗಿರುತ್ತಾರೆ. ನಂತರ I'll read the relevant portion. ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ಉಭಯತ್ರರು ಗಲಾಟೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆಂದು ಮಾಹಿತಿ ತಿಳಿದು ಬಂದಿದ್ದು, ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ನಾವುಗಳು ಉಭಯತ್ರರನ್ನು ಠಾಣೆಗೆ ಕರೆಸಿ ವಿಚಾರಣೆ ಮಾಡಿದ್ದು, ಶ್ರೀಮತಿ ವಿಜಯಲಕ್ಷ್ಮಿ ಹಿರೇಮಠ್ ಅವರು ಹಾಲಿ ಮನೆಯಲ್ಲಿ ಬಾಡಿಗೆದಾರರು ವಾಸವಾಗಿದ್ದು, ಶ್ರೀಮತಿ ಸ್ಮೃತಿ ಹಿರೇಮಠ್ ದಟ್ ಈಸ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರಿಗೆ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ವಾಸವಿರಲು ನಾವು ಪ್ರತಿ ತಿಂಗಳು ಬಾಡಿಗೆ ಹಣವನ್ನು ನೀಡುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಶ್ರೀಮತಿ ಸ್ಮೃತಿ ಪ್ರದೀಪ್ ಹಿರೇಮಠ್ ಅವರು ಇದಕ್ಕೆ ಒಪ್ಪಿರುವುದಿಲ್ಲ. ನಂತರ ಹಾಗೂ ನಾವುಗಳು ಮತ್ತು ಸಂರಕ್ಷಣಾಧಿಕಾರಿಗಳಾದ ಶ್ರೀಮತಿ ಶ್ರೀದೇವಿ ಅವರು ಸ್ಮೃತಿ ಅವರಿಗೆ ಕಾನೂನು ಸಲಹೆಗಳಂತೆ ನೀಡಿದರೂ ಸಹ ಈಗಾಗಲೇ ಬಾಡಿಗೆದಾರರು ವಾಸವಾಗಿರುವ ಮನೆಗೆ ಆಕೆ ಮತ್ತು ಆಕೆಯ ತಂದೆ ತಾಯಿಗಳು ಸೇರಿಕೊಂಡು ಸ್ಥಳದಲ್ಲಿ ಕಾನೂನು ಸುವ್ಯವಸ್ಥೆಗೆ ಭಂಗ ತರುವಂತೆ ನಡೆದುಕೊಳ್ಳುತ್ತಿರುತ್ತಾರೆ. This is the way she has occupied the house. In spite of their being a tenant. ಆ ಟೆನೆಂಟ್ ಪಾಪ ಅಡ್ವಾನ್ಸ್ ಇದು ಏನು ತಗೊಳ್ದೆ he had to flee the house. The way these people created a scene on the said day.
But at the time of filing the petition in 2019, where she was saying?
Milords, she was staying in another, she and the first petitioner, who are husband and wife, were residing separately.
ಆಯ್ತ್ರಿ, ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡೋಗ ಯಾವ್ದೋ ಶ್ರೀನಿಲಯ ಅಂತ ತೋರಿಸಿದಾರಲ್ಲ, ಸಿರಿನಿಲಯ. ಸಿರಿನಿಲಯ.
ಸಿರಿನಿಲಯ, ಹಾ.
11th B cross.
D group, Milords. D group.
layout. ಲಿಂಗದೇರನಹಳ್ಳಿ.
ಲಿಂಗದೇರನಹಳ್ಳಿ. That was the house made.
ವಾಸ ಇದ್ರು ಆವಾಗ.
ಹೌದು.
ಸೇಮ್ ಮನೆಯಲ್ಲಿ.
ಹೌದು. Thereafter, he filed for divorce because of marital discord and they started living separately. He filed for divorce. Divorce notice hogadmele, she files the domestic violence, she files 498A, she files several cases. Adaralli she sought this.
This is only an interim award.
Haudu.
I can direct the trial.
Alla, idralli she sought, Milords. Idralli, in domestic violence,
yes,
she has
madam,
sought.
what are the grounds in revision?
Milords, revision, she is well qualified, Milords. B graduate. Also, house is already provided by him. Maneg rent to ಕಟ್ಬೇಕಾಗಿಲ್ಲ. Already given by the husband.
ಅಂದ್ರೆ ಈಗ ಹೌಸ್ ಇದಾರೆ, ಆಲ್ರೆಡಿ ಇದಾರೆ.
ಹೌದು, ವಾಸವಾಗಿದ್ದಾರೆ. She is residing in that house only.
ಹೌದು.
After removing the tenant. So all she has to do is basic earning for her own living since she is well qualified.
ಸರಿ, that's all.
Law is very well settled, Milords.
ಹಾ.
I'm sorry.
That's all ಅಲ್ಲ?
That's all. ಅಷ್ಟೇ. ನಾನೇನು ಹೇಳಿ.
My lord, I admit that I'm a BE graduate. It's a well-known fact. My husband is a BE and Udaipur MBA, a reputed institution of all India level, he was a graduation. Later, he joined to one of the MNC, multinational corporation by name Manhattan Associates, which had office at America, yes, and the branch is at Bangalore. Seeing the position of my husband, I thought that I was employed in a small concern. Soon after the marriage, I decided that my husband is working in such a big organization, and he too advised me, your going to job is not at all necessary. You take care of my mother, my sister, my brother-in-law. What is the necessity of you going to job? He advised me.
That's why you have quit the job anta. Next.
That is right, my lord. That's the thing. Then, after that, we were staying in the same house, as agreed upon by my learned counsel in Lingjarnalli. It's very unfortunate thing, my lord. My husband left me in a roadside and he went to Japan without consulting me, without telling anything to me. Therefore, what I did was, I was forced to file such applications. Then, I entered into his house. It is not anybody's house. And the protection officer named by the social welfare department, she rescued me on the advice of the honorable court. And the protection officer protected me. And he had seen that I entered in the house and I'm staying in a comfortable position. Now, this application, this revision petition application is filed on 3/1/22. 3/1/22. Now we are in 4th month of 24. That is 2 years and 3 months have elapsed. There is a specific order by this honorable court. It says that all maintenance cases have to be disposed of within 1 year. Looking at the pathetic situation the wife may face from time to time. Nevertheless, the counsel, in the trial court also she is the counsel, here also she is the counsel, and in the appellate court also she was a counsel. And for one or the other reason, she is prolonging the case for non-payment of 25,000. It is just not 5% of my husband's salary. I am filing my husband's salary certificate to this honorable court consideration. And my husband has taken 10 lakh rupees loan from HDFC Bank, and once he has taken 25 lakhs from HDFC loan.
Copy none.
And for that, 34,000 per month EMI and this thing, 64,000 rupees per month EMI he is paying. Since 3 years he is paying, since 4 years he is paying. Now, the honorable lower trial court has fixed a mere sum of 25,000. And later on, my learned counsel objected me, we have not filed assets and liabilities certificate as stipulated by the act. Later I submitted that also before the lower court, as well as copy is produced to this honorable court also. I have fulfilled all the commitments, all the responsibilities the regulatory authorities has fixed. Nevertheless, for one or the other reason, my counsel is asking for this thing, revision, all that. Now, I am in a beg, borrow or steal position. 15 lakh rupees have to come as arrears from my husband, taking only rupees 25,000 per month as maintenance. I have given the calculation also to this honorable court. Out of that is
ಡ್ಯೂ ಇದೆಯಾ? ಡ್ಯೂ ಇದೆಯಾ ಈಗ?
ಹೌದು ಸರ್. ಹೌದು ಸ್ವಾಮಿ, 15 lakh rupees due ಇದೆ ಸ್ವಾಮಿ. Once on the order of the district court, they have paid 1,94,500. And once on the perusal, the honorable direction of from this on court, she has paid only 2,000. That is
2 lakhs, not 2,000.
2 lakh. Forgive me, my lord. It is 2 lakh. In all, I have received 3,94,000.
Balance to be deposited
500.
5 lakhs rupees ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ.
ಅದ್ಯಾವ್ದು ಆರ್ಡರ್ ಫಾಲೋ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಹಾ.
ಆಮೇಲೆ
Payment
ಈಗ
ಮಾಡ್ತಾ
ನನಗೆ
ಇಲ್ವಾ madam?
ಎಲ್ಲ ಆರ್ಡರ್ ಫಾಲೋ ಆಗಿದೆ.
ದಯಮಾಡಿ
Balance 25,000 ಕೊಡ್ತಾ ಇದೀರಾ?
ದಯಮಾಡಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಇದ್ರೆ ತಾವು.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಮಾತಾಡೋದ್ ಬಿಟ್ರೆ ನಾನು
ಅಲ್ಲ ಆಯ್ತು, ಈಗ
ಇಲ್ಲ, ನಂದು ಇನ್ನೂ
25,000
ಮುಗ್ದಿಲ್ಲ.
ಕೊಡ್ತಾ ಇದೀರಾ ಅಂತ ಕೇಳಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕಂಡೀಷನಲ್ ಸ್ಟೇ ಇದೆ. There was a
ಏನಂತ?
conditional stay subject to depositing of 2 lakh. In this case,
ಹೌದು.
that 2 lakh was deposited.
ಆಮೇಲೆ
Earlier 2 lakh, ಈ 2 lakh.
Earlier 2 lakh ಅಲ್ಲ, 1,94,500.
1,94,000 ಸ್ವಾಮಿ, I stand corrected. ಎರಡನ್ನು she has withdrawn by furnishing an indemnity bond.
whether you have continued to pay the amount or not, ಇಲ್ಲ.
Millards?
25,000 per month ಕೊಡ್ತಾ ಇದೀರಾ ಇಲ್ಲ?
ಅಲ್ಲ, there is a stay ಸ್ವಾಮಿ, ಅದು ಮಾತ್ರ stay.
ಇದೆ ನೋಡಿದೆ ನಾನು ಆರ್ಡರ್.
ಹಾ.
ಹಾ.
There is a stay of that. Subject to the condition, 2 lakh should be deposited. ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅವರು ವಿಡ್ರಾನು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
My lord,
In fact,
ಲೆಟರ್ ಕಂಟಿನ್ಯೂ. ಮೇಡಮ್
ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ, ಅವ್ರು ಆಮೇಲೆ ಕೇಳೋಣ ಅವ್ರದ್ದು ಏನಾದ್ರು.
My lord, in all 15 lakh rupees that due as on today, that is for 60
That is
months into 25,000, which comes to 15 lakh. Out of that, I have received 3,94,500. Net arrears is 11,05,500. I have not received any pay,
which is not.
from 3 years. Because of the this
Memo
stay order and all
ನಾನೇ
that.
ಹಾಕ್ತೀನಿ
I
ಬೇಕಾದ್ರೆ.
have sustained with that. ಲಿಟರಲಿ ಇದು ಹೇಗಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಬಕಾಸುರನ ಹೊಟ್ಟೆಗೆ ಅರೆಕಾಸಿನ ಮಜ್ಜಿಗೆ ಅನ್ನೋ ತರ ಆಗಿದೆ. 15 lakh ನಿಮ್ದು ಅರಿಯರ್ಸ್ ಇದೆ, ನೀವು 3,94,500 ಕೊಡ್ತೀರಾ, 11,05,000 rupees ಡ್ಯೂ ಇಟ್ಕೋತೀರಾ. ಯು ಆರ್ ಡ್ರಾಯಿಂಗ್ ಎ ಸ್ಯಾಲರಿ ಆಫ್ 5 lakh and for 4 months. My lord, more than 5 lakh he is earning. My husband is earning 5 lakhs, more than 5 lakhs. He is a well qualified, well settled. He used to trip abroad for his employment purposes. All that. He is in a very fantastic position. Nevertheless, he is not paying only mere 25,000.
That's all. Our scope is very limited with regard to the interim maintenance is concerned.
ನನಗೆ ಅವ್ರು ಕೊಟ್ಟಿರೋದ್ ಬರೀ ಎರಡೇ ಡಾಕ್ಯುಮೆಂಟ್, ಏನೋ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂದ್ರು.
ಅದು ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲ. Your ಅಂದ್ರೆ your client
ಲೋನ್ ಅದೇನೋ ಎರಡು
your client borrowed the loan
ಹಾ.
of rupees 25 lakh from the HDFC bank, as well as also 10 lakhs rupees earlier. Earlier EMI was rupees 32,730
ಅವ್ರೇನೋ ಸ್ಯಾಲರಿ.
and subsequently 64,000 is the EMI.
ಗೊತ್ತಾಯ್ತು
These are the payments you are also making the payment ಅಂತ
ಗೊತ್ತಾಯ್ತು.
ತೋರಿಸಿದಾರೆ ಅಷ್ಟೇನೆ. Your
But,
capacity ಬಗ್ಗೆ
ಇನ್ನೊಂದು ಇನ್ನೊಂದು, there was only stay of the maintenance order ಅಷ್ಟೇ. Proceeding stay, I had not sought, it was not stayed also. But till today, evidence commence ಮಾಡೋಣ.
ಆಯ್ತು, ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿ ನಾವು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ.
ಸ್ವಾಮಿ ನನಗೆ
Any reasonable amount that the court thinks that I have to pay, if at all I have to pay, because I have already produced.
Arrears payment ಮಾಡಿ.
Arrears ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಷ್ಟೇ. My humble submission is, she being an engineering graduate.
ನೋಡ್ರಿ, now she is not in any employment.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದೇ no, I am just bringing to your lordship notice.
Maybe she is an engineering graduate, but not in employment.
The court, plethora of judgments also say, is the wife though qualified, is she entitled to just sit at home idle, not doing anything? May I just read one relevant para ಅಷ್ಟೇ ಸ್ವಾಮಿ, just madam.
ಕೊಡಿ, citation ಕೊಡಿ.
One relevant para I will read.
Paragraph ಯಾವುದು?
One ನಿಮಿಷ ಸ್ವಾಮಿ. Page number 4 ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ರೆಲೆವೆಂಟ್ ಮಾತ್ರ ಮಧ್ಯಭಾಗದಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ಕಾಪಿನು. In the middle.
Does not help indolence.
Yes, my lords.
Well, as
The law
well
does
as-
not help
well,
indolence
does not
as well as
want-
idols. So also does not want an army of self-made lazy idols. Everyone has to earn for the purpose of maintenance of himself or herself. At least has to make sincere efforts in that direction. If this criteria is not applied, if this attitude is not adopted, there would be a tendency growing among such litigants to prolong such litigation and to milk out the adversary who happens to be a spouse, once dear but far away after an emerging of litigation. If such army is permitted to remain in existence, there would be no sincere efforts of amicable settlements because the lazy spouse would be very happy to fight and frustrate the efforts of amicable settlement because he would be reaping the money in the nature of pendentile alimony and would prefer to be happy in remaining idle and not bothering himself or herself for any activity to support and maintain himself or herself. That cannot be treated to be aim, goal of section 24. It is indirectly against healthiness of the society. It has enacted for needy persons who in spite of sincere efforts and sufficient effort are unable to support and maintain themselves and are required to fight out the litigation, jeopardizing their hard-earned income by toiling working hours. In the present case, wife Mamta Jaiswal has been awarded 800 per month as pendente light and has been awarded the relief of being reimbursed from husband whenever she makes a trip to Indore. Yotmal for attending matrimonial case for date of hearing. She is well qualified woman, once upon a time obviously serving as lecturer in education college. How can she be equated with the gullible woman of village? Needless to point out, the woman who's educated herself with master's degree in science, master's degree in education, would not feel herself alone in traveling from so and so, when at least a bus service is available. Submission made on behalf of Mamta, wife, is not palatable and digestible. This smells of oblique intention of putting extra financial burden on the husband. Such attempts are to be discouraged. Plus, even another decision of our own High Court also says the same thing. Lords. ಇದರಲ್ಲೂ ಲಾಸ್ಟ್ ರೆಲೆವೆಂಟ್ ಪ್ಯಾರಾ ಬಂದ್ರೆ ಪೇಜ್ 6 ಅಲ್ಲಿ ಅಡ್ಮಿಟೆಡ್ಲಿ ಒಂದ್ ನಿಮಿಷ
ಇದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಮೇಡಮ್.
ಅಲ್ಲ, ಅಡ್ಮಿಟೆಡ್ಲಿ ದ ಪೆಟಿಷನರ್ ನಂಬರ್ 1 ವಾಸ್ ವರ್ಕಿಂಗ್ ಪ್ರಿಯರ್ ಟು ಅವರ್ ಮ್ಯಾರೇಜ್.
ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಆದ್ಮೇಲೆ
ಪ್ಲಸ್
ಬಂದಿರೋದು.
Plus, admittedly, she says she is not working. And they agree she is a engineering graduate. She comes from a very well-off family. Her father, in fact, in her own name, has business, Byadgi Menshinkaidu traders from you. They have huge business, poultry farming.
ಎಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ.
ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ.
ದಯಮಾಡಿ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದ್ರೆ ಕೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
At the relevant time, it will be produced in the court.
ಮಾಡಿ.
She is not somebody a destitute or something. She has business in her name, earning income. But all she wants to do is sit at home.
ಎಲ್ಲ ಮೆರಿಟ್ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ನಾವು.
My lord.
But all she wants to do is seek an maintenance from the husband, sit and not prolong the case and not go ahead with the matter.
Yes.
Evidence ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಇದ್ರವರೆಗೂ ಅವ್ರ ಓನ್ ಕೇಸು. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
Enough. Heard the petitioner counsel and also the counsel appear with the respondent. The present revision petition is filed challenging the order passed by the trial court in criminal miscellaneous number 221 of 2019, wherein interim maintenance was awarded against the respondent herein to pay maintenance of rupees 25,000 and also directed not to disturb the petitioner's possessions of house stated in the complaint cost title, and the first respondent shall pay the rent of the said premises along with other charges. If the petitioner is not residing in the said premises, the first respondent shall provide separate residence to the petitioner till the disposal of the main petition. The same has been challenged before the appellate court in criminal appeal number 9 of 2021. The appellate court dismissed the appeal and confirmed the order passed by the trial court. Hence, the result revision petition is filed. The main contention of the counsel appearing for the revision petitioner before this court is that the respondent is also a engineering graduate and she cannot sit idle and put only responsibility on the husband and claim maintenance.
My lord.
The council, ತಡೀರಿ ಒಂದ್ ನಿಮಿಷ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೇನೆ, ಕೇಳಿದಿನಲ್ಲ ಇಬ್ರುನು, ಆಯ್ತು, ಕೇಳಾದ್ಮೇಲೆ ಆರ್ಡರ್ ಬರಿತಾ ಇದೀನಿ. The council also vehemently contend that when she was well educated, being a BE graduate in computer science, and she was earlier employed in a reputed company, namely Fact Personnel Private Limited, and is drawing a sum of rupees 2,70,000 as annual salary. Apart from the same, respondent, as per the orders of the CGM, has been occupying the rented premises belonging to the petitioner's sister, and the rent for the same is being paid by the petitioner. That being the case, a sum of rupees 25,000 per month, in addition to the rentals paid by the petitioner herein, is totally against established principles of law, and hence order needs interference of this court. The council also vehemently contend that both the trial court as well as the first appellate court fails to consider the grounds which have been urged, and hence it requires interference. The council also, in support of her argument, relied upon the judgment of the Delhi High Court. Damanpreet Kaur versus Indermeet Juneja and another, and brought to notice of this court. Discussion made in paragraph, page number 4, with regard to an observation made that law does not help indolents as well idols, so also does not want an army of self-made lazy idols. Full stop. Everyone has to earn for the purpose of maintenance of himself or herself, comma, at least, comma, has to make sincere efforts in that direction. Full stop. If this criteria is not applied, comma, if this attitude is not adopted, comma, there would be a tendency growing among such litigants to prolong such litigation and to milk out the adversary who happens to be a spouse, comma, once dear but far away after an emerging of litigation. The council also relied upon the judgment of this court passed in criminal revision petition number 1324 of 2015, wherein also discussion was made with regard to the capacity of the husband. That husband is running a provision store, and he is having a responsibility of taking care of his mother and unmarried sister. And considering the same, reduce maintenance from 10,000 to 5,000, which does not require any interference. Per contra, the council appearing for the respondent would vehemently contend that council would vehemently contend that the trial court, while considering quantum of compensation while awarding
Maintenance.
maintenance, taken note of the capacity of the husband. And also in paragraph number 5, discussed that salary slip furnished by the respondent for the month of December 2020 has taken note of that he is getting salary of rupees 2,09,874 per month. And hence interim maintenance has to be decided on the basis of this salary. And also taken note of the settled principle of law that the petitioner, being the wife of first respondent, is entitled to live a life in the manner of first respondent is living, and awarded an amount of rupees 25,000, and not passed any order without any material. And also taken note of the fact while passing an order for residential order, and hence it doesn't require any interference. the council also would vehemently contend that even though an order has been passed to pay maintenance of rupees 25,000, only complied with the order passed by this court but not continued to pay the maintenance of rupees 25,000. And hence it doesn't require any interference. Having heard the petitioner counsel and also the counsel appearing for the respondent, and admittedly, the maintenance order is passed, that is only for interim maintenance, and a matter is pending before the trial court for consideration on merits. It is also not in dispute that husband is working and earning, and also nothing is placed on record that presently the respondent is working and getting any salary and any income. It is also the contention of the respondent counsel that when the marriage proposal was made and she was asked to leave the job and not to continue the job, and hence she left the job immediately after the marriage.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮ್ಯಾರೇಜ್ ಆದ್ಮೇಲೆ she was working.
And whether she has continued the job or she has left the job immediately after the marriage is a matter to be tried before the trial court, since matter is pending before the trial court. Admittedly, as on today, she is not working, and when such being the case, and when the husband is also getting salary of rupees 2,09,874, in view of the certificate produced by himself before the trial court, taken note of the said fact into consideration. And when such being the case, granting of maintenance of rupees 25,000 per month, it doesn't appears to be an unreasonable. And also it is a contention that now she is staying in a rented premises of petitioner's sister's house. And also it is very clear by the order of the trial court that if she is not living in the said house wherein address is shown in the cast title, then made an alternative accommodation. And now it is the contention of the petitioner counsel also that when the tenant was there in the premises, he was thrown out and she has occupied. And whether she has thrown out or forcibly occupied is also again a matter of trial. And admittedly, she is staying in a premises belongs to the petitioner or his petitioner's sister. When such being the case, and having taken note of material on record, I do not find any error committed by the trial court in determining and quantifying the maintenance of rupees 25,000, looking into the material available on record. And hence I do not find any error committed by the trial court and first appellate court also, while passing an order, consider the material on record and also taken note of the fact that the learned magistrate, while quantifying the amount of maintenance, discussed the same in paragraph number 30 and taken note of the gross salary of the husband and also taken note of total deduction of rupees 50,675 and further claims that he has to pay rupees 64,000 towards the EMIs. And all these factors were also taken note of the said fact into consideration by the appellate court. It comes to a right conclusion that the amount quantified by the trial court is not exorbitant and unreasonable. And court has to take note of status of the parties are also while awarding maintenance also, and hence I do not find any ground to interfere with findings of the trial court and also the appellate court, and hence there is no merit in the revision. The counsel appearing to the respondent would vehemently contend that the arrears of maintenance has not been paid, and now there is a balance of rupees 11,05,500.
But that is not correct. I think new.
And the same is disputed by the revision petitioner. And trial court has to take note of the date of passing of order. And also if any such arrears, the respondent is given liberty to proceed against the petitioner in accordance with law. You can file petition account, you recovery ಮಾಡ್ಕೋಬಹುದು. And also the counsel appearing for the petitioner would submit that though petition was filed in 2019, till date evidence has not been commenced. And hence the trial court is directed to dispose of the matter expeditiously. Since matter is pending from last 5 years and matter has to be decided on merits, protecting the interest of both the parties with regard to the payment of maintenance as well as the rights of the parties has to be determined in accordance with law. With this observation, petition is disposed of.
45, Rajesh A.
Hearing for the petitioner, my lord. Counsel on record is not available today because his father is hospitalized. So
Who
he was
filed
here-
the memo?
Myself.
You have filed the memo.
Yes, my lord.
What happened to the council?
counsel's father is hospitalized. He was here only.
Ah.
So he had to rush to the hospital. So I don't know whether he will be able
Today
to,
only he hospitalized?
no, after
Today only he hospitalized?
like around 11:30.
Huh?
11:30.
That is
So he had
today
to rush
only?
today morning.
Today only?
Yes. He was here only,
You are from the same office or different?
same office.
Same office.
Ah.
Then you argue.
No, file is with the
Huh?
senior. File is with the senior. He just rushed
Oh,
back.
You would have collected the file from your senior. When you are here, you would have collected the file from your senior.
I was not here.
Matter
only.
138.
138, sir.
Good. The junior counsel submits that the senior counsel was here and his father admitted to hospital and hence he left the high court. And counsel for the respondent would submit that case of the year 2017 and matter is pending before the court for more than 7 years. And there is an urgency in the matter. And hence memo is moved before this court. And in view of medical emergency of the petitioner counsel, list this matter immediately after summer vacation.
Much obliged.
Pass over.
Passed over matter 41. P. Shankar Reddy.
ಮಧ್ಯಾಹ್ನ ನೋಡಂಬ್ರಿ ಯಾರು ನನ್ ಕಾಣಲ್ಲ ಅದೊಂದು ಮತ್ತೆ 2:30 ಒಂದು ಇದೆಯಾ ಯಾವ್ದು Fish Pandari. Assist the prosecution along with this note. A1. 439 petition. Bail petition. Here ಮಾಡಿ. ಅಷ್ಟನಾ? ಮುಗೀತಾ? ಗೊತ್ತಾಗ್ತಾ advocate system ಏನಂತ
Madam, pass up the people. 48 ನಮ್ದೇ ಅಲ್ಲ first. 48 ಅಲ್ಲ. ನಮ್ದೇ. 47. ಸರಿ. This is directed to that's also.
Yes, Your Lordship.
Petition brought by the accused numbers. Please, Your Lordship, is in custody from the date of votes. Yes, Your Lordship. Earlier, tama order itto. Your Lordship, it is Your Lordship has stated, Your Lordship, it is Your Lordship. Yes. change your lordship now. Out of 10 witnesses, eyewitnesses, your lordship. CW 21245. And interested witnesses, your lordship, examined. Independent witnesses, your lordship, at CW 6 and 7. Independent eyewitnesses, your lordship, turned hostile. And the rest of the witnesses, your lordship, eyewitnesses are given up. Now, your lordship, 70 witnesses, totally 70 witnesses are there, your lordship. Now, by virtue of that, ಯಾಕೆ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಅವರೇ ಬಿಟ್ಟಿದ್ದಾರೆ. ರೀಸನ್ ಗೊತ್ತಿಲ್ಲ, your lordship, because ಅವ್ರೇನು ಸಪೋರ್ಟ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಏನೋ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. Because eyewitness, those are the eyewitnesses, hello. Now only the supported witness, your lordship, interested witnesses, that they are from the same village, and they more particularly they are relative to the disease. Now my submission, your lordship, since from past 4.5 years, your lordship, is languishing in jail, your lordship. Now, at this point of time, your lordship, there is no, I don't think your lordship is tampering the witnesses or tampering the, only the material witnesses are now left out. Only the material witnesses are left out now. That apart, your lordship, subsequently, your lordship, A3, your lordship, has been released by this court, your lordship. That is A3 Muttesh, by order dated 20th December 2023. Case number 3, your lordship. ಇಲ್ಲ. Against that release, he has filed an application, now petition, to cancel the bail now. The first CW1. ಅವ್ರು ಮತ್ತೆ ವಾಪಸ್ ಹಾಕಿದ್ದಾರೆ ಈಗ. ಅದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. That apart, your lordship, ಇವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಲಾಂಗ್ ಕಂಪ್ಲೇಂಟ್, ಸುಳ್ಳು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Ground, your lordship. Since the witnesses, the other, yes. Five and 6, your lordship, CW 5 and 6 are turned hostile, your lordship. That is your lordship. Lordship, what happens, your lordship? ಹಾಕಿದ್ದಾರೆ. Pending ಇದೆ ಅದು. Now what is the ground they have urged in that, your lordship, cancellation, ಅವ್ರು ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ನಮ್ಗೆ ಥ್ರೆಟ್ ಕೊಟ್ಟ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. For that, your lordship, they subsequently have received you accused number 4. Accused number 4, your lordship, that your lordship get a charge sheet. Yes. 81 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ, your lordship. ನಂತರ ಆರೋಪಿ 2 ಡಿ ಸ್ವಾಮಿ, ಆರೋಪಿ 1, 3, 6 ಅವರು ಸಂಜೆ ಮದ್ದೂರಿನ ಮನೆಗೆ ಬನ್ನಿ ಮಾತಾಡೋಣ ಎಂದು ತಿಳಿಸಿದ್ದು. ಅದರಂತೆ ಅದೇ ದಿನ ಆರೋಪಿ 1, 3, 6 ಅವರು ಮದ್ದೂರಿನ ಚೆನ್ನಗೌಡ ಬಡಾವಣೆ ವಾಸವಾಗಿರುವ ಆರೋಪಿ 2 ಸ್ವಾಮಿಯವರ ಮನೆಗೆ ಹೋದಾಗ 2 ಸ್ವಾಮಿಯವರು ತಮ್ಮ ವಾಸದ ಮನೆಯ 3ನೇ ಮಹಡಿ ರೂಮಿಗೆ ಕರೆದುಕೊಂಡು ಹಾಕೊಂಡೆಲ್ಲರಿಗೂ ನೀಡಿದನ್ನು ಪ್ರಕಾಶ್ ಅವರಿಗೆ ಮುಗಿಸಿಬಿಡೋಣ ಎಂದು ಹುಡುಕಿದ್ದಾನೆ. ದಿನಾಂಕ 24/12 ಆರೋಪಿ 1 ಮತ್ತು 5 ಅವರು KAS 443-13 ಮೋಟಾರ್ ಸೈಕಲ್, ಆರೋಪಿ ಸೋ ಅಂಡ್ ಸೋ, ಆರೋಪಿ 3 ಮೋಟಾರ್ ಸೈಕಲ್, ಆರೋಪಿ 4 ಮತ್ತು 6 KA 11X0604 ಮೋಟಾರ್ ಸೈಕಲ್ ಮದ್ದೂರಿಗೆ ಬಂದು ಎಲ್ಲರೂ ಪ್ರಕಾಶವನ್ನು ಮೋಟಾರ್ ಸೈಕಲ್ ಹುಡುಕುತ್ತಿದ್ದಾಗ ಮದ್ದೂರು IB ಬಳಿ ಇದ್ದ KA MM 1429 ಕಾರನ್ನು ನೋಡಿದ ಆರೋಪಿ 3ರವರು ಪ್ರಕಾಶ ಮದ್ದೂರು IB ಯಲ್ಲಿ ಇದ್ದಾನೆ ಎಂದು ತನ್ನ ಮೊಬೈಲ್ನಿಂದ ಆರೋಪಿ 6 ಮತ್ತು 1ರವರ ಮೊಬೈಲ್ಗೆ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದ್ದು. ನಂತರ ಆರೋಪಿ 1, 2 Please. Now, your lordship, since there are several witnesses yet to be commenced, your lordship, now as a concept of your lordship is the bail is the rules, there is, and in fact, your lordship, other than the interested witness, your lordship, none of them supported. The eyewitness, eyewitness examine ಆಗಿರೋದು your lordship, one is Nazir, PW. PW 4, your lordship, PW 6, 5 and 6. Yes, that your lordship get at page 101, your lordship, my petition. That is 6, your lordship, that is nearby, he was turning a tea stall where the incident has taken place.
But totally 10 total 10 eyewitnesses are there, my lord. Out of 10, PW 1 to 6 were examined. Out 1 to 6,
Yes.
1 to 4 have supported. 1 to 4 have supported. Supported.
Yes.
I have produced the deposition statement. 5
1
and
to
6
4
are not-
supported. They are the claiming to be there along with the disease. The independent witnesses are not supported.
There- Yes, my lord, they have played fraud on the court, my lord. If there in the petition itself, they have not stated that there are other witnesses
No, no.
who have supported the case of the prosecution. They have only concentrated that 5 and 6 are turned hostile. In the petition now, which has been placed before lords, they have not placed 1 to 4. I have placed in my IA, my lord. ಅಷ್ಟೇ
ಅಷ್ಟೇ,
ಅಷ್ಟೇ ಯಾಕೆ ಅವ್ರು ಅಷ್ಟಕ್ಕೆ ರಿಸ್ಟ್ರಿಕ್ಟ್ ಆಗ್ತಾ ಇದಾರೆ.
That is. I have stated my petition. But prosecution, your lordship. Prosecution witnesses could have Yes.
But your lordship's order was challenged before the Supreme Court. Even we also find intervening application. Supreme
This-
Court has upheld your
No, no,
lordship's
this-
order. I
Supreme
placed
Court-
in my IA. This, yes.
This
again,
order
your
I
lord-
challenge the Supreme Court, your lordship, Supreme Court. That's rejected, your lordship. Then however, the liberty was given, your lordship. However, we consider, your lordship, is a paper book which he has filed 110 page. However, we consider it is appropriate to direct the respondent prosecution to get the statement of the eyewitnesses be recorded in the instance of the priority basis of the earliest. However, if no progress is taken in the pending trial, the petitioner will be at liberty to file the fresh application seeking bail before the trial court. Yes, thereafter, it was rejected and yes. Now rejected and your lordship present, I have filed the presentation.
My lord, yes, my lord. Lord, this petition, my lord, we have filed a successive bail application. Lord, after your lordship's order in the year 2022, Lord, in same year, they went to Supreme Court. Supreme Court has rejected the contention and noted the injuries and well-reasoned order of lordships has upheld the order. Lord, subsequently, my lord, they come to this honorable court and they filed an application for accused number 3. Lord, in their petition, it is very much clear that they have suppressed the entire thing, that there are total eyewitnesses. Recently, my lord. Even this petition was also, my lord, is listed in portal 9. After I submitted, it is listed today for this court. ಹೋಗಿತ್ತು ಅಲ್ಲಿಂದ
By
ತಿರ್ಗಾ
oversight, it has been posted before that court. Then we submitted.
Even another petition also been listed, my lord. Another accused, ಅದು ಅಲ್ಲಿ ಹೋಗಿತ್ತು ತಿರ್ಗಾ ಅದನ್ನು ಪ್ಲೇಸ್ ಮಾಡ್ಸಿ.
ಅದನ್ನ ಪ್ಲೇಸ್ ಮಾಡಿ ಹೇಳಿದೀವಿ ನಾವು. It has been before the same bench ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Yes, yes, my lord, your lordships have petition number. Petition number, that is 482 of 22, 21. ಇಲ್ಲ criminal petition number.
Give me petition number 482.
Another petition, my lord, which has been filed by another accused.
Another accused.
ಅದು ಅಲ್ಲೇ ಹೋಗಿತ್ತು ತಿರ್ಗಾ ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ತಿರ್ಗಾ ಇಟ್ ವಾಸ್ ಪ್ಲೇಸ್ ಬಿಫೋರ್ ದ ಸಾನಾದ. ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾವ್ದು ಆಗಿರ್ಲಿಲ್ಲ ಅವ್ರ ಮುಂದೆ. But I am not aware. This petition is accused number 4, my lord.
Probably your lordship, A7. So
Lord, now totally 10 eyewitness were cited as eyewitness, my lord, by the prosecution. Out of 6 have been examined, other rest were given up. 1 to 4 clearly supported. I have placed the deposition copy, my lord, before the lords, and along with 5 and 6, even including 5 and 6 also I have placed. Lord, in so far as ನಾನು ಹಾಕಿದ್ದೀನಿ ನಾವು ಹಾಕಿದ್ವಿ, I have placed it. 5 and 6 ಮಾತ್ರ ಹಾಕಿದ್ದಾರೆ. I have placed 1 to 4 also. Now, my lord, as far as this petitioner is concerned, he has stabbed the deceased, and from his petition, from his person, bloodstained cloths, knife, vehicle, everything has been seized under Mazar. Bloodstained cloths, vehicle. Yes. Seize ಆಗಿದೆ from his position. Now, my lord, there is a definite case, and even including eyewitnesses have clearly stated that this petitioner also assaulted the deceased. Lord, when such being the case, my lord, this court should not entertain the bail application, my lord. Apart from that, my lord, where accused number 3 is parity, where they are citing. But there is clearly fraud on the court, my lord. That was placed, even including your, in this petition also, my lord. Kindly see the petition copy. Lord, paragraph number 11 to 14, my lord. Page 5, I think. from 12, my lord. It is submitted the prosecution has totally examined 6 witnesses as PW 1 to 6, amongst them 1 Nazir and Borappa are the eyewitnesses to the incident, and they were present at the time of incident, but they have completely turned hostile to the case of prosecution, and they have not supported the case of prosecution. It is relevant to submit herein that none of the witnesses examined by prosecution have specifically supported the case of the prosecution. It is submitted that in a similar circumstance, this honorable court has been granted bail to accused number 2 and 3 and 7, and this petition is arranged as accused number 4, and therefore he is also entitled for on ground of clarity. Hence, it is submitted that since none of the prosecution witnesses examined were supported the case of the prosecution under changed circumstances, the petitioner has approached this honorable court. And they have not even stated the Supreme Court order itself, my lord.
No, supported specifically, yes. Because contradictions, your lordship, the notice. Contradictions in the cross-examination.
And they have not cited the Supreme Court order. ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ petition ಅಲ್ಲಿ 482 ಬಗ್ಗೆ ಅಷ್ಟೇ ಹೇಳಿದ್ರು.
Specifically stated as I have stated. What said it has happened by my colleagues as well. Colleagues ಮಾಡಿದ. That is second relation. For me, it is second relation. Correct. Some mistakes has been covered. I have noticed, your lordship, later after filing it. After filing it, I noticed, your lordship. I'm actually sorry, your lordship.
In this case, my lord, the petition is arrayed as accused number 4 in this case. 4. There are 6 eyewitnesses to the incident. And 1 to 4 are supported the case of prosecution. And 5 and 6, my lord, they are hostile to the prosecution, but in cross-examination by PP, admitted to the support the case of prosecution. Support ಮಾಡಿದ್ದಾರೆ page 6.
Really?
Page 80, my lord, in my
Page
petition.
80.
Yes, yes, no, my. Yes, yes, Nasir.
Okay. Some code.
Your lordship, last line, your lordship.
Last word. One colleague,
ಅಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್ ಲಾಸ್ಟ್ ಲೈನ್ ಲಾರ್ಡ್ಶಿಪ್ ಲಾಸ್ಟ್ ಲೈನ್ ಅದೇ ಪ್ಯಾರದಲ್ಲಿ. ಸೊ ಚುಚ್ಚಿದರು ಓಡಿ ಹೋದರು ಹೆಸರು ತಿಳಿದಾಗಿ ಅವರ ಪ್ರಸನ್ನ ಮುತ್ತೇಶ ಶಿವರಾಜ ಯೋಗೀಶ್ ಹೇಮಂತ್ ಎಂದು ಅವರು ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ನಂತರ ಆ ಕಾರಣಗಳಿದ್ದವರು
Already that
Since-
lordships have considered insofar as 2 and 7 separately are bifurcated. Including lordship, same lordships also.
ಲಾರ್ಡ್ಶಿಪ್
they have mentioned that
ಲಾಸ್ಟ್ ಲೈನ್
there is
ಲಾರ್ಡ್ಶಿಪ್ ಓಡಿ ಹೋದರು ವಿಳಾಸ ತಿಳಿದಾಗಿ ಅವರು ಪ್ರಸನ್ನ ಮುತ್ತೇಶ ಶಿವರಾಜ ಯೋಗಿ ಅಂತ ಹೇಳಿದರು ಎಂದರೆ ನನಗೆ ತಿಳಿದು ಬಂದಿತ್ತು ಎಂದು ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿದರೆ ಅಂದರೆ ಸರಿಯಲ್ಲ.
ಏನ್ ಮಾಡಿದ್ರು?
No, in total your lordship, no.
Six is.
No, in lordship, no, it is not related in your lordships. It is this wordings, your lordship. It is in respect of the whole para, your lordship, that word.
one statement only, sir. Same.
PW6, your lordship.
ನಮ್ಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಅದು. ಬಂದು ಎಂಟೈರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಲೆಕ್ಕದಲ್ಲಿ ಮಾಡಿದ್ದಾನೆ. ನೋಡಿಲ್ಲ ಮಾಡೋರು ನೋಡಿ. ಏನ್ ಒಂದು ಅವ್ರ ಆ ಗ್ರೌಂಡ್ ಇರ್ತಾ ಇದ್ರಲ್ಲ ಅದೇ ಗ್ರೌಂಡ್ ಕೊಟ್ಟಿರೋರು.
Lordship, para next. Great, Your Lordship. Sorry, Your Lordship, because my colleagues has been made the mistake. ಅದು ಅಲ್ಲ. That Your Lordship, that words may be explained. Yeah, because
No, last pair other put. Registry is directed to place this matter before the learner. Last line is last line specific. Last para. Registry is directed to place this matter before the you. ಆಗಿರೋದು. Clarification as to whether the 58 KP Act is maintainable or not. ಹೌದು. Yes. Yes, please. Yes.
Brilliant. Time bound, your lordship. Time bound to conclude the. Six months, your lordship. 6 months. Lordship.
The 58 KP Act is maintained, appealable or not in this case. Not.
No, petition in this case, my lord. ಲಾರ್ಜರ್ ಬೆಂಚ್ಗೆ ರೆಫರ್ ಆಗಿದೆ ಮ್ಯಾಟ್ರು, ರೆಫರ್ ಆಗಿದೆ. ಬಟ್ ಜಿಮ್ ಪೋಲ್ GM ಪೊಲೀಸ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪ್ರೆಸೆಂಟ್.
ಅದು ಕಾಣ್ತಾ ಇದೆ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಕೂಡ ಎಂಟ್ರಿ ಮಾಡಿದ್ರು ಪ್ರೆಸೆಂಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ. ಮತ್ತೆ ಪ್ರೆಸೆಂಟ್ ಜೇಮ್ ಪೊಲೀಸ್ ಅಲ್ಲಿ ಎಲೆಕ್ಷನ್ ಇರೋದ್ರೆ ಎಂಟ್ರಿ ಮಾಡೋ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ. ಅಲ್ಲ ಸುಮ್ಮನೆ ಎಲೆಕ್ಷನ್ ಬೇರೆ ರೆಮಿಡಿ ಇಲ್ಲ ಸುಮ್ಮನೆ ಅಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಸರ್. ಸಬ್ಮಿಷನ್ ಇದೆ. WP ಕೂಡ ಪ್ರೆಸೆಂಟ್ ಕೂಡ ಆರ್ಡರ್ ಬೇರೆ ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಅವ್ರ ಮುಂದೆ ಆರ್ಡರ್ ಆಗ್ತದೆ ಸ್ವಾಮಿ. ಪ್ರೆಸೆಂಟ್ ಜೇಮ್ CPC ಅಲ್ಲಿ ಇಟ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಆಗ್ತದೆ ಸ್ವಾಮಿ. ಅಲ್ಲ ಸಬ್ಮಿಷನ್ ಇದೆ. ಅದು HGPF ಆಫೀಸಲ್ಲಿ ಇದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಕ್ಕೆ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರೆ ಅನುಕೂಲ ಸ್ವಾಮಿ.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಡೈರೆಕ್ಷನ್ ಕೊಡಕ್ಕೆ ಸ್ಟೇ ಆಗಿರೋ ಬಗ್ಗೆ, ಯಾಕೆ ನಾಳೆ ಎಲೆಕ್ಷನ್ ಇದೆ ಸುಮ್ಮನೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಆಟೋ ಕಾಪಿ ಸಿಗೋಷ್ಟೊತ್ತಿಗೆ. ಬಾಯ್ ಈ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. Section of